Well, please, Lordship. My Lord, I beg to mention item number 12. My Lord, here kindly allow me 1 week time to file additional affidavit, my Lord. Yes, my Lord, in the last occasion, while I was filing the affidavit in opposition, I have not enclosed one document. So I need to enclose them.
You have not filed your reply affidavit.
My lord, I'll be filing. My lord, here, actually what happened is, the first detention order was till 27th of October.
No, but you filed. Can we dispose it of now?
My lord, there is an extension of the detention order,
Okay.
which I have not received.
Where is that?
Yes, that's why I need 1 week time to file additional of it to
Why,
enclose that
why 1
extension.
week? Why week? This is a personal liberties involved.
Next, in the next.
Next Wednesday, my lord.
Yes,
Next week.
yes.
Next Wednesday.
Okay, right. Mr.
Ethiopia
Etiwapom, learned counsel for the
government advocate.
then government advocate submits that he would like to file the latest detention order of the petitioner within 4 days. Within 5 days.
Yes.
Prayers allowed. Mr. Takakichu, learned counsel for the petitioner, has not filed his affidavit in reply on the ground that he has not received a copy of the latest
My
detention.
lord,
This is the matter on Wednesday as paid for by the parties.
much obliged.
Much older.
So, Lordship,
Yes,
Lordship, I beg to mention item number 19.
19.
Yes, Lordship.
Yes, what about it?
Lordship, the council is in bereavement.
Oh,
I'm appearing on
okay.
behalf of B. Devnath.
Okay, right. A general prayer has been made on behalf of Mr. B. Devnath, learned counsel for the appellant on the ground that he is under bereavement. This is the matter
Next week, Your
in
Lordship.
the next week. Bye.
May it please, my lords.
Yes,
My lord, for item number 24, LCR have been received. Lordship, if a direction may be given for paper book preparation, lordship.
then why is it in the hearing stage? Yeah, right. As, as LCR has been received by the registry, we need to prepare the paper. This is the matter after breaking.
May it please, my lords.
Yes.
Lordship, item number 14.
Yes.
On behalf of Mr. B. Jimomi, my colleague, lordship. He's indisposed today, so may it be listed after vacation, lordship.
Have you filed a written objection to the application under 389?
Lordship, I'm not in the case, my colleagues in the case. Who's indisposed today?
So both are indisposed. Acha, Mr. Who is for the petition? Who's for the appellant? Have you informed the appellant?
Lordship, I couldn't.
We have no objection.
Have you received the paper book?
Yes, Lordship, we have received.
Okay, has the prosecutor received the paper book? You've got no idea.
Most probably, lordship, because we were being
Because paper book is made, that is listed for hearing. Right. Miss, what is your name?
Mika, Lordship. Mika H.
Mika,
H.I.
learned counsel for the appellant. Submit. So, when do you want?
after vacations.
Yes, madam.
Lordship, if next week, Lordship, on 13.
Okay. But one thing, you have got to file an objection to the application under 389. You see, otherwise it becomes very difficult for the court to grant bail. There is a element of the effect. Since you're not the counsel. Ms. So, for the appearance, submit that she received the copy of the paper. Mr.
Kiangami, lordship.
Kiangami submit that the learned PP, Mr.
B. Jimomi.
Please, is having some personal difficulty. Please. Accordingly, leave this matter in the next week.
May I please, Your Lordship, I beg to mention item number 10. Kindly grant 2 weeks' time to file my objection to the additional affidavit.
This is a church.
Yes, Your Lordship.
Okay, right. Mr.
I intend, Your Lordship.
I Imchin, learned counsel for the,
Respondents, Your Lordship.
all the respondents.
Yes, Your Lordship.
appearing for all the respondents. Submit that he'll be filing additional affidavit
No,
within.
objection to their additional affidavit.
Objection to the additional, objection. Objection to the additional affidavit within
2 weeks, Your Lordship.
2 weeks. List the matter after 2 weeks.
Much obliged.
Please, your lordships. Your lordship, I beg to mention item number 16.
16, yes.
Yes, your lordship, here, notice upon the respondent number 2 is yet to be completed, your lordship. So some time may be given.
Madam, first of all, notices have been issued on all the applications. But there is the condonation of delay application, correct?
No, your lordship, the IA is bail, your lordship.
No, IAS for bail, but there is an IAF 21 of 2022. Give me the file. Item 16.
Yes,
No?
your lordship.
Item 16, there is an IA criminal 21 of 2022.
Yes, your lordship.
What is that IA? Unless the condonation is taken up first, we cannot take up the other IA at the appeal itself. But I find that various orders have been issued. 2020, 2021. Condonation of delay of 346 days.
Yes, your lordship.
This has to be taken up first. You're convicted, correct?
Yes, your lordship, please continue.
Yes. Any challenge? Any objection to the delay? I don't think there should be an objection. This is regarding liberty of a person. He's in jail. Right. Heard, Miss?
Vitere.
We correct. Learned counsel for the applicant. Also heard Miss S. Mere, learned additional PP.
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 Yes.
How many PPs do you have?
3.
3 PP.
Yes.
Learned PP. This is an application for donation of 346 days in filing the appeal against the impugned judgment and order dated 22/10/2021 passed by the Learned Special Judge bracket FTSC Dimapur, Nagaland in GR number 537/2017, by which the appellant was convicted under section 354/376 bracket 2 bracket IPC 1, it's Roman 1, IPC read with section 4/12 of the POCSO Act, as sentenced to undergo rigorous imprisonment for 15 years with a fine of rupees 30,000 from an ID RI for 1 year. Just give me POCSO. This yes, Learned PP submits that she has got no objection to the delay being controlled. On considering the grounds of condoning the delay as enumerated in the application and keeping in view the submission made by the Learned PP, we find that sufficient cause for the delay has been made out. Accordingly, the delay is condoned. I is accordingly disposed of. Now go to the main case. Now, what is this other IA? Oh, notice has been issued. What is this? This is under 389.
Yes, your lordship.
Now, before that, we have got to admit the appeal. Right. Third, Miss
Vitere.
Vithere, learned counsel for the appellant, who submits that this appeal has been filed against the judgment and order dated 10th of September. Same thing, you copy that. admit the appeal, call for the LCR. Issue notice returnable in 4 weeks. Ms. S. Mere accept notice, PP accept notice on behalf of
The state. Your Lordship.
on behalf of the state. Appellant to take steps for service of notice upon the rest. No. Appellant shall serve a copy of the shall furnish a soft copy of the appeal to the registry of this court, who shall thereafter forward the same to Miss S. Mere, learned PP. Miss S. Mere, the learned PP shall forward the soft copy of the appeal to the OC of the which police station?
Women PS Dimapur.
Women PS Dimapur in as much as the case pertains to Women's PS case number 65/2017. The OC Women's PS shall give the copy of the give a copy of the soft copy of the appeal along with a copy of this order to the respondent number 2. So we'll change it a little bit. Huh? We just say appellant to take steps for service of notice upon the respondent. Okay. By submitting a hard copy of the appeal, the registry shall thereafter forward the hard copy of the appeal along with a copy of this order to Ms. S. Mere, who shall send the same to the OC of the Women's Police. What women?
Women PS Dimapur.
Women PS Dimapur. Inasmuch as the case pertains to Women PS case number 77. The OC of the Women's PS case shall serve a copy of the notice and of the appeal and the notice to the respondent number 2 and give a report thereafter. This is the matter of the court. The thing is that one reason we are doing it because now he'll be the only person who knows the address. Very difficult to find. So then wait. That's okay. Acha, wait.
Please, Lordship. Lordship, I beg to mention item number 15, Your Lordship. On
15,
behalf of the counsel for the respondent number 1, Your Lordship.
Yes.
Lordship, 2 weeks may be granted, Lordship, to file an affidavit in opposition, Lordship.
You are appealing for whom?
I'm appearing on behalf of the leading counsel for the respondent number 1, Lordship, R.A. Rongmai.
Have you informed the other side?
Yes, Lordship.
Just
Yes.
give us this item 15. What are you challenging here? The pending is not.
Lordship, I'm not a counsel in this case, Lordship. However, the leading counsel, R.A. Rongmai, is undergoing eye treatment, Lordship. And his junior Pakin Shapo, whose name has been reflected in the post, is also out of patient, Lordship. So they have approached me to make a mention on their behalf, Lordship. And I'm told that they have taken the consent from the petitioners also. YP Gupta.
You have for respondent number 1 only, no?
Yes, Lordship.
What about the others? he has been given time earlier also. Okay, right. Mr.
Beto Ferro, Your Lordship.
Vito Ferro appearing on behalf of Mr. R.A. Rangme, Learned Counsel for the respondent number 1. Praise for
2 weeks, Lordship.
2 weeks time to file
Affidavit in opposition.
affidavit in opposition. Praise the Lord. Then you write. This court by order dated 17/5/2023 had issued notice to the respondent and steps were to be taken within 3 days. Nothing is reflected in the office orders with regard to whether any steps have been taken by the petitioner, by the appellant, or service of notice upon the respondent number 2. Wait. No, don't say that. Wait. However, uh, office order dated 6/11/23 states that petitioner has not taken, appellant has not taken, item number 15. Appellant has not taken steps for service of notice upon the respondent. But he's not here also. Okay. Let us wait for the counsel for the appellant to be here.
No, Lordship. He's from Dimapur, Lordship.
Right. In the beginning, you write, huh? No one appears for the appellant. Appellants. Then thereafter, at the bottom, you write. Appellant shall take steps for service of notice upon the respondent number 2 by registered post proceeding. In terms of the order dated 17/5/2023, within 5 days. Release the matter after 2 weeks.
Obliged, Madam.
Yes. Where is the yes? Come. This is a writ appeal, correct?
Lordship.
Where is the question of filing an affidavit in opposition? There's no need. No affidavit is required. I forgot. Thanks to my brother. This is a writ appeal. There's no requirement of filing a writ appeal. I mean, affidavit. Everything is there.
I'm told by the leading.
No. What? Just say. I paid for so and so. No, we said prayers aloud. No, just say. Uh, the prayer made by the council for the respondent number 1 is not granted in as much as no reason has been given as to why any additional affidavit need to be submitted in the written. No, not required.
Obliged, Madam.
May I please, your lordships? I beg to mention item number 17. Service notice upon respondent 6 and 7 is still awaited.
Madam, were you a party in the writ petition?
No, I was not a party.
Then how can you file this writ appeal?
Your lordship, the petition was regarding the land that we donated to the state.
Maybe, but have you filed an application, leave to file a third party, you're filing a third party appeal?
Yes, your lordship.
Are you allowed to file?
Yes, your lordship, because we are grieved by the order.
Did you file any application for leave to file third party appeal?
Your lordship, I'll be consulting my senior upon that.
Where is your senior?
Your lordship, he's from Dimapur.
This is with regard to posts to be filled up, correct? You are relying upon some agreement made between the government and the village or the clan that the post will always be filled up by the villagers. I mean, they will be given preference, Correct.
Yes, your lordship.
And preference will only apply when everything is equal. It cannot be in perpetuity.
Your lordship, the point was set aside by the court. And the land was said to be compensated, and that's what we are coming to the court for. We were not actually compensated.
When was the land donated?
Your lordship, in the 1960s.
Are you ready for a hearing?
No, your lordship.
Let us upon the private response.
You have to ask a senior. Third party appeal, not a party at all. I'm not saying that you cannot fight. In instances, you can fight. You consider, because your senior is not here, we won't go further. Await service report on respondents number 6 and 7. This is the matter after the speech.
Yes, your lordship. Much obliged.
For motion, item number 1.
Please, your lordships. I've come before your lordship under Article 226 of the Constitutions of India Bring for setting at liberty the detainee Shri Roshan Lengmai presently detained. in
So we
Central
issue
Jail.
notice. We have to issue notice, I think. Okay, right. Heard Mr.
M. Kasar.
M. Kasar, learned counsel for the petitioner, who prays that the petitioner of detention order dated 31/8/23, approval order dated 11/9/23, and confirmation order dated 17/11/23 should be set aside. Issue notice returnable in. Before that, you write the orders have been, the impugned orders have been passed in connection with Kohima PS case number 0014/23 under section 20B, 25 bracket 1A bracket 1AA of the Arms Act and section 7/8 NSR.
NSR, yes.
NSR. The issue notice returnable in
3 weeks.
3 weeks. Mr. A.
E.
E.
Tipao.
E.
Tipao form.
From accept notice
From the other respondent number 1 and 2.
1 and 2. Then with 3. With 3.
3 is Union of India.
Who is the council? Yes, Mr. Yangarwati. You are the CGC. Then you accept notice. Respondent. Mr. Yangarwati accepts notice on behalf of respondent number 3. This is the matter after 3 weeks.
Much obliged.
For motion, item numbers 2 and 3.
Or should we list it next week? Because Christmas is coming also.
Next week, the
Next week.
first item, my
Yeah,
lord.
first item.
Next week, whether I can file affidavit or not. At
You
least
try,
two, at least
you
2
try,
weeks, my
you
lord.
try.
You get the records because
Yeah.
it's a case of illegal detention.
Yes.
So if you, there's a illegal detention, and it is on the question that 1 day or 2 days, if it is a illegal detention, also it's a illegal detention.
Okay. List the matter, list the matter next Thursday.
Thursday.
On which date Mr. E. Thiba form shall produce the records.
Much of-
Item numbers 2 and 3.
Lordship, this application is for
Okay,
amendment of the.
okay, okay. Heard, Mr. Your name is not here.
Lordship, my name is not in the IA,
Okay,
but in the
okay.
main.
Heard Mr. Fosika Forte, Learned Counsel for the petitioner. Applicant writ petitioner. Who feels that he may be allowed to amend the writ petition. Any objection?
No objection.
Mr. A. Tivakom, Learned Counsel for the state respondent, submits that he has got no objection to the application. Accordingly, the prayer of the petitioner for amending the writ petition in terms of para 5, 6, and 7 of the application is allowed. Petitioner to submit amended writ petition
Lordship,
within
within a day, Lordship,
within
within the course of the day,
within 2 days.
20 days. And I'll furnish the copies to the respective.
Mr. E. Tivapom, you want to file any? Nothing is there.
No
Nothing is
objection.
there.
No objection.
This is the matter in the next week.
Lordship,
I is accordingly disposed of. Then in the main case, you write, list the matter in the next week.
Lordship.
My lord, in the main case, I need time. I need to file affidavit. my lord.
Okay, in the main
In 2
case,
weeks.
you write, Mr. E. Tivapom is granted 3 weeks time to file. No, but let it be there. Okay, it's granted 3 weeks time to file. Affidavit in the position on the writ petition and the amended writ petition, which he has already been furnished with. Correct?
Yes, my lord.
Lordship, it can be come up next week,
Huh?
not next week, Lordship,
Convenient.
since this is a legal detention, Lordship, and Christmas is coming, so.
Oh, this is again the legal
Yes,
section.
Lordship.
Okay. Okay. Okay, next week, Thursday.
Lordship.
Yeah, then Mr. E. Tivapom shall produce the records.
Much obliged. Obliged, my lord.
For motion, item numbers 4 and 5.
May please, Lordship.
Yeah.
So in here also the petition is bring for amendment of the writ petition.
Okay, Mr. Lima Wapang, Learned Counsel for the applicant petitioner, pays for amendment of the writ petition. To submit it, is Tivapong, the Learned Counsel for the state respondent, submit that he has got no objection to the application being allowed. So accordingly, the application is allowed. Petitioner shall submit an amended writ petition
By tomorrow,
within 2 days. List the matter
next week,
in the next week on Thursday or Wednesday.
Wednesday, Lordship.
List the matter on Wednesday. But Wednesday is a DB day, no?
Wednesday is the DVD.
Then a DB day. Oh, those others also you put all Wednesday, sorry. DBs are all Wednesday. Thursday, all Thursday.
Oh,
Because,
Justice, please.
yes, because DB will be there only on Thursday. As the A. Sevapom shall produce the records on that.
Much obliged.
For motion, item numbers 6 and 7.
Yes, madam, any objection?
Yeah, here I'm appearing for the respondent number 4, Your Lordship. And the main respondent will be the board.
No, there is a delay of 30 days. No?
Yes, Your Lordship, so notice, Your Lordship.
No.
Your Lordship, I am only for respondent number 4, Your Lordship.
Okay. Who's for 1, 2, 3? We'll take up the entire matter today.
Council is preparing for
Gauhati,
decision.
you're there? For
No,
the central government?
Central.
Oh, okay. You're for the central government.
Yes, ma'am.
So, how many respondents are here? There are five respondents.
Who was appearing for these respondents in the writ proceedings? Who was appearing for the respondents in the writ proceedings?
Your Lordship, I also appeared, Your Lordship. Yes,
two-
however, this, since, respondent five, Your Lordship, the board, it's an autonomous body, so Your Lordship, unless and until an instruction.
Who was earlier appearing for
Uh,
respondent number 5?
Your Lordship, there was a writ of, batches of petitions, Your Lordship. This is not the only, another. Decided together. So in some, our senior, Akito was appearing, and in some I appeared, Your Lordship, in some of the cases.
Did you appear for the respondent number 5 in any of the writ
Yes,
proceedings?
Your Lordship, I also appeared in.
And who appeared?
Yes, Mr. Council, Mr. Roy, Mr.
Yes, my lord.
There is some noise coming from your office, I don't know, from your room. Please tell them to keep quiet, or please make yourself mute if it's not.
Please, please, everybody, quiet. Hello? Yes, my lord, I beg your pardon, my lord.
Yes. Otherwise, we will have to disconnect you. We are disturbing the court proceedings.
Mr. Roy, kindly.
I'm meeting. Let Miss Advocate Meadow.
Secretary, registrar, you are for the number, you are
For Your Lordship,
for the government.
for the government.
And this board of homeopathic
And the
medicine.
board, it's an autonomous body, Your Lordship.
Madam, I think your central government is appearing for 1 and 2. 1, 2, and 3. Correct. 1, 2, and 3. Correct.
One, two, and three.
1, 2,
1, 2, and 3. No? Madam, the board is under the government of Nagaland only.
Your Lordship, it's an autonomous body, Your Lordship. Even on the last occasion, also in the single bench writ petition, Your Lordship, we were given an instruction, Your Lordship, because it's an autonomous body. So unless and until they give an instruction to appear, Your Lordship, that's the problem. Your Lordship. Though it's up to the board, Your Lordship.
Madam, this will only delay the proceedings. We only
Uh,
want to
For
condone the
me, as
delay.
far as the delay of 30 days, I mean.
No, no, but if you, because this respondent number 5 is there also.
Yes, yes, that's why, Your Lordship, five is the main, Your Lordship, in this case, Your Lordship. The board is the main. That's why unless until an instruction come, because, Your Lordship, this is not the only case, Your Lordship. There was a batch of writ petitions, Your Lordship. There was another 6 writ petitions there, Your Lordship, and there were almost 500 petitioners, Your Lordship.
Milord, we are the only appellant over here, Milord. May I intervene, Milord?
Okay,
Milord,
yes,
I am Roy Milord from Kolkata High Court, appearing in virtual conference. Milord, this delay may be condoned, condoned, Milord, because otherwise it will be delaying further.
yes, oh no, you see, the problem is no one is appearing for the respondent number 5. That is the only thing.
Milord, it is at your discretion, Milord. This is actually, they will appear in course of time when the matter comes up. But as far as delay is concerned, it is absolutely on your discretion, Milord.
That's it.
They can't, delay is, we have done the delay. They cannot object against it. It is your discretion. Even if they object, it is, Milord, your discretion that is final.
Just a minute. So, you have accepted for the purpose of condonation only 5, and then we should notice it in the main appeal.
Yes, Your Lordship. There is a stay also, Your Lordship. So,
No,
the,
stay, we won't. We are only issuing notice. Only,
oh, Your Lordship.
right, heard, Mr.
Medovero.
No, heard Mr. N.K.
Roy.
Yes, independent Roy.
Mr. N.K. Roy, Learned Counsel for the applicant.
Appellant.
There's a 30-day delay in filing the appeal against the impugned judgment and order dated 20/09/2023, passed in WPC 152/2019. Is there only one writ petition of various
Your
writ
Lordship,
petitions?
this is a common judgment and order, Your Lordship.
Okay, so 159, no, in the batch of writ petitions, the lead case being WPC 152 of 2019. Okay. Mr.
That in Moli, madam.
Zeren Moli appearing for the respondents number 1 to 3.
Yes, one only, madam.
One?
One.
No, you take it 1 to 3. 1 to 3, you've got nothing to say, man. 1 to 3 and Miss
Livika, Your Lordship.
Levika appearing for response number 4 and 5, submit that they've got no.
For Your Lordship.
4 and 5, submit that they've got no objection to the delay being condoned. On considering the grounds of delay enumerated in the application and keeping in view the submissions made by the counsel for the parties, we find that sufficient cause for the delay has been made out. Accordingly, the delay of 30 days is condoned. IA is accordingly disposed of. Then in the next case, the appeal. Okay.
Next, I will not pertains to
No. Wait. We won't say that we have got no objection. We'll just say that submit that they have not received instructions as on date, and accordingly, accordingly, some time should be given to them to obtain instructions. Full stop. Next para. On considering the grounds taken in the application for condoning the delay of 30 days appears to be unintentional. We find that the reasons given for the delay are sufficient to be condoned. Accordingly, the delay of 30 days condoned, I is accordingly disposed of. Then in the appeal, you're right. Heard Mr.
Medovero, Lordship.
No, heard Mr. N.K. Roy, Learned Counsel for the appellants. This is an appeal against the judgment and order dated so and so, marked in the batch of writ petitions. The lead case being WPC number 152/2019. Issue notice, returnable in 4 weeks. Mr. Z in Moli accept notice on behalf of respondents number 1 to 3, while Ms. Divika accept notice on behalf of respondent number 4. Issue notice to the respondent number 5 by registered post with hearing. No, issue notice, Mr. No, Mr. N.K. Roy. No, the appellant shall take steps for service of notice upon the respondent number 5 by registered post with AD within 3 days,
4 days, Lordship.
4 days. This is the matter of the 4 weeks. Then in the IA for stay, just write that notice is issue notice on the application for stay. The Mr. So-and-so accepts the CGC on behalf of responsible party, while Ms. Livika appears for number 4. Issue and a petitioner to take steps for service, appellant to take steps for service of notice upon the respondent number 5. By registered post within 4 days.
Milord, we have already served notice.
No. You have served. What do you mean you have served notice? Unless we direct that notices be served, you cannot serve it.
Yeah, no. Okay, Lord.
Right, Lord.
Right, Lord.
For motion from the supplementary cost list, item number 26.
May I please, Lordship? Lordship, this is habeas corpus matter. I was arrested on 11/7/2023 while I was going home. Thereafter, I was taken to the police station and I was booked under Supreme PS case number 14 of 2023 under section 120B of the IPC, read with 25(1)A, 25(1)A of the Arms Act. Your Lordship, while I was in judicial custody, I was served copies with the detention order dated 31/8/2023. Along with the detention order, I was given the schedule, the letter of approval, and the information. The detention order which was given to me, Lordship, Annexure 1, page note 29.
There is no 129 in my copy.
29.
29.
Annexure 1. This is the detention order dated 31/8/2023.
Yes.
Lordship, this is the copy which was served to the OC. My personal copy was not served to me. Lordship can see in the order dated 31/8/2023, serial number 7. It was the copy of the OC Supreme PS. My name appeared in serial number 8. My personal copy was not served.
Not served to you.
Yes, my personal copy was not served.
How did you get this?
Lordship, this was given to me by one police personnel while I was in judicial custody in Central Jail, Dimapur. Then even the letter for approval, page number 31, NHA 3. This is also the copy for the OCs of PS. Page number 31, NHA 3.
Okay.
31. Page number 31, Lordship. 31.
I know. So it is on the same date.
Yes, same date. So, Lordship, copy to OC Savima PS. My personal copy was not served to me. I received these copies while I was in judicial custody in Central Jail.
Mr. Counsel, what is your case?
Lordship, apart from these 5 documents, I was not served the other documents for making an effective representation. Lordship, on 11, I have submitted my representation through the respondent number 4. And on 15, I have received
On
the
11th of
11th of September. And on 15, I have received the approval from the government. On 15, I have received in the jail. The approval order was passed on 11, but I received it on 15. So on the date I received that approval order, Lordship, in that approval order, I was given the document like proposal for my detention under NSA to the Commissioner of Police. Those documents were supplied to me on 15/9/23. So I could not make an effective representation. So again, Your Lordship, the advisory board was supposed to be constituted between 3 weeks. Detention order was passed on 31/8/23. Advisory board, there was a sitting on 6/10/2023.
advisory board is to sit within what time? What
Within
time?
3 weeks, as per section 9 of the NSA. So before my representation, detention order has already been approved by the government. Then, Lordship, I have received my confirmation order on 24/11/23, which was passed on 17/11/23. The confirmation order, in this confirmation order,
The confirmation order date is what date?
sorry,
You are
Lordship.
saying 24/11/23, now you are saying 7/11/23.
Lordship, I have received the confirmation order dated 17/11/23 on 24/11/23.
Say that.
So here my detention order was confirmed and it was extended for another period of 3 months.
Where is that? It is the page 109?
Page, yes, Lordship. 109. In the last paragraph. May I read you?
Yes.
Now therefore, the state government in exercise of powers conferred by subsection 1 of section 12 of the National Security Act 1980 hereby confirm the detention order issued in respect of the said Mr. Tingman Shimra, SS Deputy Financial and SIM, and further ordered that he shall be detained for another period of 3 months with effect from 1/12/23 till 28/2/24, within which period his detention will be reviewed as required under a provision of National Security Act. Then, Your Lordship, while
Okay. So one is the time. The ground of challenge is basically the time. That's all. And of course, on the merits, you'll want to say something, but that will question of fact. So anyway, let him produce the records then. Next week, Thursday.
Next week.
Thursday, you produce the records. And I hope your director is coming today,
Yes, my lord.
Mr.
Sharif Ahmed.
Sharif Ahmed. Heard Mr. Sharif Ahmed, Learned Counsel for the petition.
May I please, Lordship, my lord, at least your Lordship may kindly grant 2 weeks time, my lord.
No. No, 2 weeks. No. What do you mean 2 weeks? 2 weeks is a vacation time. Either you don't know the holidays when the holidays are starting, or you want to work on the holidays.
Because I need the instruction.
We'll call you to Delhi, you will, what is it?
The council, it is a question of time.
Yes.
Time is the essence. The illegal detention matter. Every day is there, as per him, is an illegal detention. When we are doing a preventive detention, you have to see the reports.
Okay, learn counsel for the uh, petitioner. Mr. List the matter, Mr. It shall produce the records pertaining to this case on Thursday.
Thursday.
List the matter on Thursday.
Obliged.
For admission, item number 8.
Next Thursday.
May I please your lordships? Lordships, here the petitioner is seeking for revocation of the detention order that it passed passed
So
by the
again, why didn't you challenge the order passed by the
uh,
the cancellation of bail order?
lordship.
Yes, madam.
Yes, lordship. It was 18/7/2022.
Madam, you're the PP. You produce the report.
Lordship.
You see, one thing I don't understand is how the magistrate could have cancelled the bail it had granted. It has got no power to cancel the bail. Only problem is they are not challenging it, madam. They are not challenging the order cancelling your bail.
Record may be called. Lordship, in fact, we challenge lordship.
Where?
Uh,
You only asked for bail before the sessions court. You did not challenge that. You did not ask for setting aside. Did you ask for setting aside?
Lordship, no, lordship.
Because that order granting bail without commenting on the whether it's a right or wrong order or illegal or illegal, that's a different issue. Once a magistrate has given an order in a criminal case under the CRPC, he has got no right to review his order. It functions officio once he passes the order. In respect of that matter, unless of course there is a violation of the bail condition. That's a different issue. There was nothing like that. Anyway, I think we'll listen next week. Madam, the records are here with you.
No, lordship. Record may be called. Lordship.
We can constitute the bench Friday also if you want. Can you bring the record?
Lordship.
Ready?
I'll give an attempt. Lordship.
Madam, there is one judgment.
Lordship.
There's one judgment of Justice Sarto, following the Supreme Court judgment in the Manipur matter, wherein it has been mentioned that if a person is in detention already,
Yes, Lordship.
in custody,
Yes, Lordship.
then if you want to go for a preventive detention, there is a further requirement to record your reasons as to why you want to have him for detention. Without, and there has to be a clear conscious application of mind, it has to be recorded that why his detention is required.
Yes, Lordship.
Without that, you have that judgment.
Lordship, I have.
What is
yes,
that?
Lordship. 2007 SCC 181.
That's the Manipur matter, no?
Yes, Lordship.
Yes.
2000?
2012 7 SCC 181, Lordship. This is the Supreme Court. Lordship,
What is the name of the case?
Lordship, it's Hydrom Konjanya Singh
Yes,
versus State of Manipur, Lordship.
The
And-
last paragraph, no?
Lordship. Lordship, I also have the latest judgments of TGLT and also the SEC. When the detainee is under custody, there cannot be a further detention, Lordship. So-
Okay, we'll have it on Friday. Otherwise, Thursday, Mr. E. Thivapom will suddenly fall sick. Too many cases for him. Vacation time coming also. He want to go here and there.
Give a copy of the judgment there, Chair, so that we may have a look.
Miss
Mika Ichaya, Lordship.
no counsel for her, Mr. Sanso, and Miss S. Mere, Leonard PP shall produce the records on Friday, day after tomorrow, huh? This is the matter day after.
Your Lordship, next week.
Oh, no.
Not this week, Your
Huh?
Lordship. Friday, it might not be possible, Your Lordship.
Oh, no. I was thinking day after tomorrow.
Just this,
You said yes. So you were thinking next week.
I was under the impression that it would be next week. Yes, Your Lordship, I'll give an attention, Your Lordship.
No. Okay.
Friday, Lordship. Yes.
Day after tomorrow. Huh?
Much
You
appreciated.
try if it's possible.
For admission, item number 9.
Yes, madam, in the meantime, you can give me your citations. Okay, just. Yes. What is
Your
the-
Lordship, when you find my additional affidavit, state additional affidavit?
No, it has been sent to the
Yes,
ministry.
it has been sent to the central ministry.
So,
And
Why? is
and
it-
where I have no hand.
Huh?
State has no hand.
But why is it sent there? Can't you frame the rules yourself? Why is it sent to the ministry?
Cabinet has approved, because in the act, there is a provision that it has to be approved by the central ministry. That's why we're sending.
I see.
So when it comes back, we'll publish it.
The rules have to be approved by the ministry.
Yes.
Is it correct?
Lordship, yes.
Then
So cabinet approval has been received as per his affidavit. And so on the last occasion, Lordship, when he filed the affidavit, he stated that for approval, it has been sent to the central ministry. And also on the last hearing, Lordship, this court has given a direction saying that to, yes,
Reminder.
to take steps, to send a reminder, Lordship, to expedite the process, because already, Lordship, this is a 2021 case. This direction for notification of
No,
rules.
but then this letter was sent to this draft rules was sent, I think, recently only.
Lordship,
When was the draft rule sent? Draft rules was sent when? I think
11th August.
11th,
No, 1st September 2023. You'll find your Lordship in my additional affidavit.
Okay, so I think have you sent a reminder?
We are sending.
No, we are sending to the different issue because this court has directed you on the last date, on 1st/11/2023, the state shall take steps to send reminder. So 1 month has gone. Have you sent a reminder or not?
Mm, Lordship, I'll have to find out, but I'll send, I'll send.
If you have not sent, please send.
Yes.
Are you appearing for the central government?
No, I'm for the state.
The central government, the party?
Lordship, Central is not made a party because the
Now,
action was to be taken by the state respondents.
but now
Lordship.
since the thing is that you make them a party here.
Yes,
You make them a party here, you file an application.
Lordship, we can do that.
Yeah,
Lordship.
by day after tomorrow, we are sitting, we'll treat them as a party, then we can put pressure on them. Otherwise, now to difficult. Okay,
Yes, Lordship.
right.
Lordship, also, I have a small request, Lordship, but the rule has not been, copy of the rule has not been given to me, Lordship.
Hasn't it been
So-
given here? There is some draft rule here in the affidavit opposition. This is at the page 21. Isn't this the draft rule, page 21? Is this the
Yes,
draft
yes,
rule? That is the
yes.
draft rule, I think.
Lordship, I don't have a copy with me, so if a copy can
No,
kindly.
you haven't been
furnish to
given
me.
a copy of the affidavit opposition?
Lordship, I don't remember receiving this copy, Lordship. So if,
Affidavit in opposition file will respond number 1 and 2. Additional Secretary, the Department of Health and Family Welfare. You have that affidavit, madam? You have that affidavit?
Lordship, I don't have
Affidavit
that.
filed
I
on
only have
20th
this
of-
affidavit, Lordship.
Oh. Mr. Moore, you give her a copy?
I'll give
Okay.
that to look.
Okay, right. Mr. Moore Imchin, a learned senior government advocate, submits that he will inquire with the department as to whether a reminder has been sent to the Ministry of Health and Family Welfare with regard to the approval being sought for by the state government for publishing the state mental health care rules framed by the state of Nagaland under the Mental Health Care Act 2017. Next paragraph. Ms. Nitya Kwadza, learned counsel for the petitioner, submits that she has not been given a copy of the affidavit in opposition filed by the respondents number 1 and 2, dated 20/10/22. So Mr. Moore Imchin submits that he will furnish a copy of the same to the petitioner's counsel within 2 days,
During the course of the.
within the course of the day. List this matter after 3 weeks, after 2 weeks. In the meantime, you file your application.
Yes, Lordship.
You file it by today, tomorrow we'll take it up. Yeah, we will take it up.
Obliged.
For admission, item number 11.
Yes,
Lordship, I filed my affidavit this morning, Your Lordship.
okay. So,
Made with your Lordships. Lordship, this is a case of preventive detention bus under NSA by District Magistrate Kohima.
yes,
And the petitioner here is the wife of the detainee. And the case of the detainee here is that he was arrested on 5/7/2023 from near Gidima Braille Park Junction, Kohima, by police personnel on alleged possession and seizure of prohibited ammunition containing 200 number of SLR, 200 numbers of SLR ammunition, and was taken to Gezocha PS police station, which a case was registered as Gezocha PS case number 5 of 2023. And he was charged under section 25(1)(a) of the Arms Act, with section 120(b) of the IPC. And after he was arrested, he was produced before the Chief Judicial Magistrate Kohima on 6/7/2023. And consequently, the case was registered as GR case number 95 of 2023. After production, the detainee was remanded to police custody for 10 days, and after which he was brought back to judicial custody and was kept at district jail Kohima.
He was sent to judicial custody when?
Yes,
When? You have to give the dates, madam.
on 6/7/2023, Lordship.
6/7/2023 was sent to judicial custody. Okay.
And when the petitioner husband, the detainee, was confined at district jail Kohima, a proposal for detention was sent by SP Kohima, the district magistrate, on 24/7/2023. And acting upon the proposal, the district magistrate Kohima passed the detention order dated 26/7/2023 against the detainee. Consequently, thereupon, the detainee was taken to Central Jail, Dimapur on 28/7/2023, and on the same day, he was furnished the copy of the detention order along with the grounds and some documents which are all annexed in the petition report. The detention order is at page 27, annexure 3.
Page?
Page 27, annexure 3.
Detention order. Yes.
Necessary page 30, annexure.
Page 30.
Page
Yes.
30, annexure 5, nearly version.
Yes.
Whereas Shri Dalendra Zelain, 48 years, son of late Zimbo, village Yalvi, permanent address Jimudina Wati, was arrested by police in connection with Kohima Gezocha BS case number 5 of 2023 under section 25, 1A arms agree with 122 of IBC. And whereas I, Shri Navasi, district magistrate Kohima, after examining and studying the facts, evidence, and police report of the case, I am satisfied that he is agreed to prevent the above person from acting in any manner prejudicial in maintenance of the public safety and order. It is necessary to detain him under section 3, subsection 2 of the National Security Act 1980. Now, therefore, in exercise of power conferred by section 3 of the said act, I, Shri so and so, district magistrate Kohima, Nagaland, hereby order that the above mentioned accused person be detained and kept in central jail in Nagaland. So, Lordship, the detention order, the district magistrate has passed the detention order for purpose of preventing the detainee from acting in any manner prejudicial to the maintenance of public order. Now coming to the grounds of detention, my lord. The grounds of detention is page 31 and annexure 6. Proposal for detention under section 3 to NSA in respect of Dalendra Zelain, 48 years, son of so-and-so, Jaliki, village Jaliki, permanent address, Jimudina Wati.
Madam, you are still in detention? Madam, you are still in detention?
You are still in detention? Are you still
Yeah.
under detention?
Yes, yes.
Now, are you still in detention under the, what you call, the normal course where you were arrested on 5/7/2023?
Yes.
In that case, what is that case number?
This case number 5 of 2023.
PS case 5 of 23, yes, correct.
You are this, in this case, you have been detained and have you got bail
No,
out there?
not then I was arrested.
And anyways, but are you still, have you got bail out there?
No, no bail. In fact,
Yes, madam. Show us the detention order by which you have taken into account that he would be likely, there are good reasons that he would be granted the bail. Where is it? In a detention order. And you have got that judgment which she was referring to, the Manipur judgment. You have it?
I don't have the judgment, but I have different,
That lady.
different citations.
She was there.
You get it 2012 7 assessment.
Let's see the records. You have got your records, yes.
Anything else? Besides that? Have you moved for bail?
Logic, actually, I applied for bail only on 27, without knowing that the detention order has been passed. But since
On 27th of?
27th of August, the detention order was passed on 26/7/2023, and I've applied the bail only on 27th, on the next day. And on the same day, the public prosecutor informed me that the detention has already passed, so the bail is still pending.
What is the allegation against him?
The allegation is that
They're selling bullets or what? You were carrying arms or what? They're selling.
not
Yes, Your
not
Lordship, he's a
selling, Lordship,
government
not
servant.
exactly selling.
He's a UBS, government servant, Your Lordship, personal. Secret personal, Your Lordship, UBC,
UBC meaning?
unarmed, Your Lordship.
Unarmed
branch constable.
And I'm branch constable.
Yes, your lordship, and he's involved in this activity, your lordship.
He obtained, the allegation is that.
It was seized from his possession, your lordship.
See, the bullets were seized from his possession.
From his
How
That is,
many?
that
How
is the
many?
allegation. 200 rounds of live ammunition, SLR ammunition. That was the allegation.
So the detention order was passed prior to the date removed for bail.
Yes, lordship. The detention was passed on 26/7/2023. I moved by bail application only on 27/7/2023.
Anything else?
Yes, lordship, in the grounds of detention, the detention order, the district magistrate has passed the detention order. The purpose of the detention order as per the district magistrate is to prevent the detainee from acting in any manner prejudicial in maintenance of public safety and order. However, in the grounds of detention, my lord, which is
So
based
the
upon
the
Annexure
question,
6.
so one of the questions here is, was there any basis for the government to have believed that he would be released on bail on 26/7/23, when no bail application had been moved on that day?
Nothing, no material has been furnished, lordship.
The word used is if released.
Correct. So we have to see whether there was material for the state government to have reason to believe that he would be released on bail. That has to be reflected in, correct?
Record is there.
No, I'm asking you, that that has to be reflected, I think, yeah, in the government decision to detain him.
Yes, your lordship, it's there, your lordship, but
That
Lordship, the documents that were furnished to me at the time of furnishing
Madam,
the.
we propose to, we'll pass the order during the course of the day. We'll set aside the detention orders. But however, we are not going to release you if you are already there.
Since your bail application is already pending.
Or whatever may be, you are already arrested in another form, so that you will be there. But we are not going to release you. We'll only set aside the preventive detention procedure. Then if you get your bail out there, very well, you get it.
Okay, then you apply the
Disposed. We'll keep the records for the time being. I'll give it to you tomorrow.
Your Lordship,
Okay.
Your Lordship.
I'll pass the order.
For admission, item number 13.
Your Lordship, here I have not received instructions, so let it come next week, Your Lordship, Wednesday.
Thursday.
Oh, okay.
Thursday. You bring the records.
Yeah, I'll bring the records, Your
Yes.
Lordship.
Right, Miss Livika.
It's, I think, the same with this petition only, because they were
It's
arrested
the
on the same day,
My lord, same day they were arrested, he is the co-accused.
co-accused.
But my lord, here, he has been already illegally detained for 5 months now, my lord. Illegally detained for 5
So, Your
months.
Lordship, let the record be brought, Your Lordship, because I
My
don't
lord,
have
an
the record.
opportunity has been given, 3 weeks has been given on the last date. And now he has been illegally detained for 5 months, my lord. And a single day is a day too many, my lord.
He has been
There is a
detained-
clear violation of section 10 of NSA, my lord.
Your Lordship,
Come on.
let, then, Your Lordship, let it be tomorrow if the bench can be constituted, then I can bring the record.
Okay. We can do it tomorrow. Friday? Yes.
On Friday, no problem. I'll bring the record, Your Lordship. I'll bring the
Friday we
record.
Friday, huh? Tomorrow.
Oh, Your Lordship.
Tomorrow, okay.
I'll bring the record.
Yes, Miss the matter tomorrow, Miss Livika shall produce the report tomorrow.
Bless, my lord.
For hearing, item number 18.
Yes. Yes.
In jail. He was convicted by the judgment order 29 August 2022 by the special judge of NDPS court.
Yes. Huh? Judge.
Judgment.
Judgment. You don't have to read the judgment, you take the entire day. Basically, he's been convicted under
Section 20B.
it cannot be 20B per se.
20B, small b.
You know, it has to be under
For transporting cannabis ganja.
200 kg.
Yes.
That should be under 20B2C, I think.
As per the conviction judgment, as per the conviction judgment. Section 20.
Give us the NDPS Act. No, NDPS Act. Yes. So what is the infirmity with the
The
judgment?
infirmities. Yeah. They have the.
He was driving. Who was driving what? He was driving a vehicle.
There were two vehicles.
Ah.
The owner is not established. Surprisingly.
No. This person, this appellant,
Yes.
was he driving the vehicle?
No, not at
He
all.
was a passenger in the
He was
vehicle.
a passenger. Driver was acquitted. The owner of the vehicle was not established. The Malkana register was not produced. The delay in sending for FSL was not explained. There are a lot of infirmities. I will satisfy those. Because the honorable special judge came to a conclusion that there are evidence against me and therefore I have convicted simply based on FSL report. Fortunately for the accused, FSL report who conducted the examination was not examined at all. Then where is the primary evidence to show that there?
No. Why is it required that which particular person in a FSL has conducted the examination is not required. Any one of them could have done it. Once it has been issued by the FSL, that it has been examined by them. That's enough.
Lordship is correct. If somebody come forward and say, yes, this is not examined, this was tested and found to be cannabis, fine. But none of the office of the FSL office had come forward and examined.
No. Is it mandatory? Is it mandatory for a FSL employee to come and prove the FSL report?
Correct.
Is it required?
Correct. Required in the sense.
I don't think so.
I'll show you, my lord. If Lordship see the FSL report, the report itself says examine some plants. When the definitions of section 2 of NTPS says plants is not cannabis. Cannabis is flowering tops. I'm coming to that. That's why I'm saying this conviction order cannot stand in the eyes of law. But if Lordship wanted to see, first of all, I'll take Lordship to the FSL report submitted by the expert. Page 42, page 42 of the paper. Page 42, my lord.
Yes.
Bottom, description of articles.
Yes.
The 10 sealed yellow envelope marked so containing some plant materials. The article examined by the expert is plant materials, not flowering tops. So from this count alone, the conviction goes. Then I take Lordship to definition, my lord, section 2, definition. What is cannabis? What is? The expert examine the practical, the article examining the expert only plants, not flowering tops. Now, Lordship, I take Lordship attention to definition. Section 2, definition. Section 2, subsection B, ganja. What is ganja? Page 5 of the Act.
I know.
Yes.
Yes.
Subsection B. Ganja. Subsection B. Ganja. What is ganja? That is the flowering or fruiting tops of the cannabis plant. Not plant at all. So the flowering top was not examined, not tested. As simple as that, my lord. Lordship has a lot of knowledge on that. So on this count alone, conviction cannot stand. And here, I have been convicted because I'm transporting ganja. What is ganja then? Definition section 2B says ganja means flowering tops. Not seeds, not leaf. I will show the judgment. I have judgment. Not leaf, not plant.
But when they say plants, plants contains everything. They don't have to mention flowering top.
My lord, that is not the definition. Definition says flowering tops and fruit. Because we cannot go beyond the act. We cannot go beyond definition section 2. That is why.
But how do you know that? How do you know that the flowering tops were not there in the plants?
This is the whole issue. Why I'm saying this? For that, in order to justify the trial court, at least the expert who examined should have come before the court, and there I have examined the flowering tops and fruit also. Not plant alone. Plant does not form as ganja as per definition section Section 2
Did,
of.
did you cross-examine the witness on this point?
Yeah.
Any of the witnesses were examined on this point?
None of them came forward.
No, no, did you cross-examine the prosecution witnesses on this point? That the flowering tops were never seized and were never examined?
My lord,
Did you take that stand during trial?
My lord, in the trial court, very clear in the trial court. So therefore, injustice has been done.
No, no, so junior lawyers, do you agree with what he says?
Yeah? Because they are learning, they are learning. The only thing-
Just joking anyway.
I keep telling my.
But one
colleagues-
thing, Mr. Counsel, this is a plan.
Yes, it's a plan.
But plans, how do you know it doesn't cover or encompass flowering tops?
My lord, I cannot go beyond the definition of any. Section 2 clearly.
Okay,
says-
next point,
Yes,
next point,
that
next
is-
point.
That is,
Next
so
point.
therefore, on this count alone, as I say, how can the trial court convict unless the alleged materials are proved to be ganja? That is the first question to be determined by the trial court, which the trial court miserably failed and come to a perverse judgment. Because without coming to the conclusion that this is really ganja as per definition given under section 2B. That
Okay,
is my
next,
observation.
next, okay.
Next, my lord. Then, lordship, there are altogether 7 witnesses, 3 prosecuting witnesses. None of them have come forward against me, pointing finger that I am the absolute owner of any ganja. None of them, except the IO. But lordship knows very well, IO is not the prior. Whatever he said is based on hearsay. Hearsay on, and hearsay is only secondary evidence, not primary evidence as far as I know.
But you were in the vehicle
I was in the vehicle.
and the ganja was seized from the vehicle.
The vehicle, I was not in the vehicle at the when the incident happened.
When the recovery was made, you were not in the.
None of us were there. That's the one point.
You are not there in the vehicle.
No one was there. It was recovered from a particular distance. Vehicle was abandoned. It was found by the police, detected, and said that they recovered ganja. And now that's why I'm saying the first issue the IO should determine was who is the real owner. The real
No,
owner
you
of
see,
ganja.
ownership.
Yes.
Ownership is not the sine qua non for coming to a finding of guilt. You might be having conscious possession or constructive possession. You could be holding the property for somebody else also.
If the question of
You see,
possession,
ownership is not required. You could be holding Mr. A's heroin till he comes back from his trip to the United States or whatever. So ownership is not the most important thing. The thing is that whether you have conscious possession, constructive possession.
in my humble submission, in case of NDPS Act, if a particular house, vehicle was found to be used, then that property has to be seized because the alleged vehicle or alleged NDPS was found, example. Now, therefore, in order to clarify the doubt, who is the owner of the vehicle? Because the vehicle was abandoned and then the vehicle, the NDPS, the ganja was allegedly recovered from the vehicle. None of us were there.
But you just told me some time ago, you told us that you were the passenger in the
No,
vehicle.
no.
No. Okay.
No, not at all. Vehicle was abandoned, my lord. That is a good question to put to me. So, on record and based on evidence, no one was in the vehicle.
Or did you run away from the vehicle or something like that? Nothing.
I did not run away.
Where were you?
I was in the village. I was in Kohima. According to the report, I was in Kohima. I came with my son to Fetchero. So when I came to Fetchero, report came from the information that police were asking me to come and report in police station.
Does in the evidence, does any of the witness say that they had seen you leaving the vehicle?
Except the co-accused. No
Oh,
one,
the co-accused.
no one saw me. No
Co-accused,
one-
co-accused means driver.
Driver. Co-accused. So,
Mr. Joe, what do you say about 52A, compliance to 52A?
not at all. That was not complaint.
Let's see if you section 52A. Because I have looked into the evidence, I don't find except the investigating officer stating out there that it was done in the presence of the magistrate. And during his cross-examination, he says that the contraband was not seized from the possession of the alleged accused persons.
Yes.
He says that the contraband was wrapped in plastic. I cannot remember the color of the plastic. It's correct to state that 20 packets of contraband where the weight of differs in each packet. However, I only mentioned as 200 kilos. It's correct that I did not check the entire packages that was seized and that I did not explain the quantity. State that the sample was not drawn in the presence of the complainant.
Yes.
The sample in duplicate was not drawn from any packet from the spot of recovery.
Yes.
So what was the compliance as regards 52A? Let's see that.
Yes. Then may I read section 52?
Yes.
Disposal of seized narcotic drugs and psychotropic substances. Subclause A, 1. Clause 1. The central government may, having regard to the hazardous nature, vulnerability of theft, substitution, constraint of proper storage space, or any other relevant consideration in respect of any narcotic drugs, psychotropic substances, controlled substances or conveyances by notification in the official gazette, specify such narcotic drugs, psychotropic substances, controlled substances or conveyance or class of narcotic drugs, class of psychotropic substance, class of controlled substances or conveyance, which are as soon as may be after their seizure, be disposed of by such officer and in such manner as that government may from time to time determine after following.
So Joe, kindly come to subsection 2.
My lord. Where any narcotic drug so has been seized and forwarded to the official in charge of the nearest police station or to the official empowered under section 53, the official referred to in subsection 1 shall prepare an inventory of such narcotics containing such detail relating to their description, quality, quantity, mode of packaging, marks, numbers, such or such other identifying particulars of the narcotic or by or the packing in which they are packed, country or of origin and other particulars as the official referred to in subsection 1 may consider relevant to the identity of the narcotic in any proceedings under this act and make an application to any magistrate for the purpose of A, certifying the correctness of the inventory so prepared, or B, taking in the presence of such magistrate photograph such as drugs and certifying such photograph as true, or C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. 3. Where an application is made under subsection 2, the magistrate shall, as soon as may be, allow the application. 4. Notwithstanding anything contained in Indian Evidence Act.
Now,
or-
whether Mr. Joe, these
My
things were done as would be appearing from the evidence,
My lord.
whether it was done.
My lord, the
Looked into that aspect.
I
of the
couldn't
matter.
really give you the answer.
Have you looked into that aspect of the
Yes,
matter?
I've seen.
Then, was it done?
No, it
Was
was
it-
not done in my
Where,
presence.
where is the certificate?
Yes.
Certification of the magistrate in
Yes.
respect to the seized goods.
Yes.
Was it there?
Certificate was there, certificate was there. By
Of the magistrate?
Yes,
Was there?
was there.
make an application to any magistrate for the purpose certifying the correctness of the inventory so prepared, taking in presence of such magistrate photographs of the drugs here. No, where is the evidence? Where,
No,
no, where is the evidence of this certification and all?
nothing, no evidence at all. Nothing, no
You
evidence.
see, what my brother is trying to say
Yes,
is that unless 52A has been complied with,
yes,
there is a lacuna on the part of the prosecution.
very much.
Only thing out here is that, you see, this 52A will come into play only when, at the time, if there was a decision taken to dispose of the drugs. So in that case, when disposal of drugs is going to be done, say due to decay and whatever, then that certificate can be used as an evidence to prove that there was a seizure.
Yes.
Now, in this case, there are two aspects. First, was the 200 kgs of ganja produced in the court to prove that seizure of 200 kgs of ganja has been done? If not, was any certificate made under 52A and produced in the court in lieu of that 200 kgs of ganja? So that is what is asked.
Yes, but that is not prepared.
That's what is asked.
Now, in addition,
Yes.
in addition to that, my lord, nowhere
Yes, to cut a long story short, no, Mr. Zoe, no, to cut a long story short, we won't ask you too many questions. How many documents were exhibited
my lord,
altogether?
yes,
Could you just read the exhibit?
correct. Please come to page 87, second last page.
Page 87, okay.
It's very simple. No Malkana register was exhibited. Interestingly, in this case, in all other cases, the
Exhibits, page 87.
7 to 83.
Exhibit 1, Somoto FIR season memo,
Yes.
packet ganja, charge sheet, signature IO, report FSL, offenses. Then,
That's
okay,
all.
so there is no material exhibit
Nothing,
and there is no 52A.
nothing.
Now, yes. So now tell us. You see, so now the PP. There's no point. Actually, I was going to ask, but then we are going to cut it short. You see, the thing is that I find, at least we are finding it's full of lacunas out here in your prosecution. They don't know how to do it. They don't know how to the police. They don't know what is required. I think training is required. So, with this case, now you see what happens is whenever seizure is made, and like for ganja, they can get, they can get rotten, and leaves, they can get eaten by rats, whatnot. So what happens is usually under 52A, you have to go and make an inventory, sample has to be taken, and that inventory is signed in the presence of the magistrate. And in lieu of proving the seizure of the seized goods, say 200 kgs of ganja, you can, which will be destroyed, of course. You can bring that certificate under 52A to prove that this has been seized, as this is the seized goods. Now, in this case, that ganja, 200 kg ganja is not here, not produced before the court. It is not exhibited. So if it is not exhibited, there is no proof that there was seizure of ganja.
The quantity was not raised by the,
No. Where is the proof that there was any seizure of ganja?
Lordship, may I take my lord to page 29? If my lord has not yet seen it.
Page 29,
The
yes.
sample was drawn in presence of judicial magistrate.
No, I'm not on the sample. Page 29.
Yes. That,
Page 29, yes. This is a photograph.
yes, this is what was drawn.
This is a photograph, Mr.
Not in
Counsel.
the presence of the judicial magistrate.
No, it has to be written down. You see, it has to be written in writing. From each packet, 5 grams of taken. Now that 200 kgs of ganja was in 20 packets. So you'll have to do, what you'll have to do is, from each packet weighs say 10 kgs. Each packet sample of 5 grams taken. And those have to be signed by the magistrate. It has to be written down. Photograph, we don't know. Where is this?
Yes.
There's no proof.
Yes, there's no detailed indications, but I'm just trying to put my lord's attention to this. The several drawn here, and again, even in her statement, the position of page 61, she has stated that I say that I'm aware about the presence case and the sample drawn in my presence. There's her statement, page 61. That is.
But how many kgs of ganja was seized?
What is
Now, where is the ganja?
that is what Malcolm Register was not exhibited to show that it was within
No,
the
no,
custody of the.
it's
it was-
not, that is
it
a
was not in
different,
the custody of the police.
that is a different issue.
Yes.
That is a different issue. You see, whenever supposing, say, liquor, supposing you seize, say, 1 bottle of liquor from somebody, goes to court. If that accused says nothing was seized from me, isn't it your duty to produce the bottle of liquor as evidence?
No.
Or supposing he says that it was water that was seized in the bottle, then what will you do? You'll have to produce it.
No, Lordship, here, the convict is even saying to the statement of saying that he was in Kohima, though he was picked up by his brother on from the rear side.
Now, another thing, let us see the 313. You see, one thing, the reason that we have had trial, let us see the charge, framing of charge. What did he say? Did he admit to the charge?
No.
So basically, he has denied the charge. Correct? When he has denied the charge, then you have to prove your case. Now let's go to 313. Where is the 313?
Page 64, my.
64.
No relevant question has been put to me.
No,
That's
no,
what I have not-
I'm more than the relevant question. I want to know your answers to the question.
Yes. They were asking about the past experience.
Anyway,
No, Lordship.
yeah,
But even he has not pleaded plea of alibi, Lordship, in his support.
no, whatever.
Now,
but,
prosecution has
But you see,
witness saying that
the law requires you, the law requires you to stand on your own legs. You cannot convict a person on the strength of his, on his weaknesses. The prosecution has to stand on his own legs, on the evidence that you produce, not on the weakness of his alibi or his case.
Lordship,
I think we have heard it. I think.
Lordship, in that case. the
Yes,
second-
yes,
first
yes,
option-
yes, yes, yes.
Lordship,
So your first case is page 29,
yes.
page 29, and then page 61 is the photograph. Correct. And then what else? Page,
Is the case. Now, my learned friend has stated that lens were examined.
huh? What is it?
Page 42 again.
Page 42. Yes.
My learned senior friend has indicated that.
Plans,
description-
plans,
yes, plans,
plans,
he- but
yes.
He has not indicated the result. The last line.
I'm sure the result.
Yeah.
Show the result.
The result is turned out. to
No,
be
no, it's,
correct.
okay, 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 the result, okay, result not, result shows ganja, okay, then,
And then worship, 3 points were determined by the learned special judge during the trial.
okay,
And one is the competencies in the abandoned car. And then the second one is page 73. Lordship.
73, yes. Yes,
Then the seize of the 20 packet weighs 200 kilograms. That is determined. The third one is culpable mental state in the possession and control of a huge quantity of. So, I reiterate the observation given by my learned session judge below in paragraph 7, 8, and 9 to 14.
no, no, basically you're saying there's no infirmity.
Yes.
You see, whenever you do these type of cases, you have to produce the seized article. If you don't have the seized article, you have to produce 52A. It's either of them. The reason 52A has been made is so that some drugs you cannot keep for a long time, and sometimes there's no space. You see, in number of areas, sometimes seizures are made of 3,000 kg, 6,000 kg. Where are you going to put it? And you cannot bring all of them to court all the time. Then they get bored. So, okay, wait, we'll pass the judgment. All right. Heard, Mr. Azo, learned counsel for the appellant. And Mr. Kiangami, learned PP. This appeal has been made against the impugned judgment and order dated
9/8/2022. Page 66,
dated
29/8.
29/8/22. Passed by the Court of the Special Judge NDPS Act, PEC in sessions bracket special bracket close case number 01/21
in GR number 35/20,
Yes.
Futsero,
Yes, ma'am.
arising out of PS check case number 09/20. The prosecution case in brief is that on the night of 29/10/2020, around 7:30 p.m., prosecution, the assistant sub-inspector, bracket PW1, along with police personnel, were checking vehicles at Zuketsa Road when they spotted a white Maruti Alto 800 bearing number NL01P2429 coming towards them. However, it took a turn, but it suddenly took a turn towards Lekromi village. On pursuing the car, they found it abandoned at Lekromi village. On checking the car with one Steno Velo PW2, who had come to the scene where the abandoned car had been found, they found 20 plastic bags of ganja. The ganja was seized and the vehicle taken to the police station, Futsal. An FIR was lodged and when?
30.
On 30/10/2020, consequent to which PS case number 09/2020 was registered under section 20B. It should be 20B2C actually. You see, it cannot be 20B. 20B, so I mean 20B will be everything. Small quantity, middle quantity, everything. No, intermediate and the commercial quantity.
There, the maximum is minimum is 10, but that's what I've given you 15 years. Yeah.
20B2C.
Yes, that is not that. That's what I'm pointing out.
Anyway,
20B.
right. What have I said? Full stop. Okay. The contraband was photographed and samples of the seized ganja was taken in the presence of the magistrate, bracket PW7, and sent to the FSL, Dimapur, for examination. The FSL report, bracket Exhibit 5, confirmed that the contraband seized was ganja, and after investigation of the case, the case I PW1 submitted a charge sheet on finding a prima facie case under section 20B of the NDNPS case act against the appellant and co-accused Luveku. Charge,
The IO is PW6.
PW6, yes, IOS PW6. Charge under section 20B of the NDNPS Act, read with section 34 of the IPC, was framed against the appellant and the co-accused on 10/11/2021. Thereafter, the prosecution examined 7 witnesses.
Yes, ma'am.
The statement of the appellant and co-accused was thereafter recorded. But no, the statement, no, not the statement, they say, the accused and the appellant and the co-accused were thereafter examined under section 313 CRPC. After hearing the final arguments for the parties, the learned trial court came to a finding. Where is the judgment?
Page 66, ma'am.
Came to a finding that there was no evidence against the co-accused with regard to transporting the seized contraband which had been found in the abandoned car. The co-accused was accordingly acquitted of the charges framed against him. However, with respect to
Accused number one.
the appellant,
Yeah,
hearing,
accused number one.
and appellant, the learned trial court came to a finding that he had hired the taxi and as such was in conscious possession of the contraband ganja, despite the fact that he was not having physical possession of the same when he abandoned the car prior to the search being conducted by the police. The learned trial court, having found the appellant guilty of possession and control of the possession of, don't say possession, just say constructive possession of the contraband. He was convicted under section 20B of the NDPS Act and sentenced to undergo rigorous imprisonment for 15 years
Yes.
with a fine of rupees 2 lakhs,
2 lakhs.
in default, further rigorous imprisonment for 2 years.
Yes, ma'am.
This part. Being agreed by the impugned judgment and order passed by the learned trial court, the learned counsel for the appellant has assailed the same on the ground that the appellant was not the owner of the contraband and neither was he in constructive possession of the same. He submits that the contraband, the seized contraband, had not been produced in the court to prove that 200 kgs of ganja had been seized. He further submits that the FSL report dated 15/1/2021 shows that plant materials had been examined by the FSL, which proved that ganja had not been seized by the police, in as much as section 2 bracket Roman 3 small bracket B
Yes.
of the NDPS Act defines ganja to be the flowering tops. Ganja to be the flowering or fruiting tops
Yes.
of the cannabis plant. Anything else? What are the other points you're taking?
That's all. Mr. N. Angami. No, he accordingly, no, next, Mr. N. Angami, the learned.
Kiangami.
K. Angami, the learned, learned PP submits that 29 submits that the what do you want to show with this page 29? They're photographs. So it proves, what does this prove, this photograph?
This observation was made on the certificate by the magistrate.
Where is the certificate?
To show that it was drawn in the
Okay.
presence of.
Drawn, where does it say it has been drawn?
Page 29 and it was taken in my presence, then again.
Drawn is different. You mean to say packed or what? Weighed? It was weighed or what? It was sealed. It was sealed, you mean? The contraband was sealed in the presence of the magistrate or weighed in the presence of the magistrate?
Drawn.
Drawn. Drawn what?
From the seized contraband. The sample was drawn.
Sample was drawn.
Yes. It says the page.
Photograph does not show drawing any sample.
What again? Page 61. The statement of. Second sentence.
I'm aware about the predicate sample drawn in my. Okay. Okay. Right. Submits that photographs were taken of the seized contraband, which was produced before the learned what do I say? The submits that sealing and packing of the seized contraband was done in the presence of the judicial magistrate first class, and that photographs of the same were also taken. He also submits that he submits that the same has been exhibited by the witnesses, by the prosecution witness before the learned trial court as EXT exhibit P5 and P6. Exhibit P5 and P6. P6 and P7.
P7.
Okay, P6 and P7. The learned PP further submits that the evidence of the magistrate first class before whom the contraband had been sealed and packed is to the shows that samples of the ganja had also been drawn in his presence. The samples drawn was then sent to the FSL for examination. He submits that the FSL report, which is Exhibit 5, very close, states that the contraband seized had given positive proof for ganja. As such, the stand taken by the Appellant's counsel that the seized contraband was not ganja is disproved by the FSL report. Exhibit 5. Next para. The learned PP also submits that the evidence of the prosecution witnesses prove that the contraband was seized from the abandoned car and that the same weighed 200 kilograms. Further, in view of section 35 of the NDNP, 35 and 54 of the NDNPS Act, which presumes the existence of the culpable mental state of the accused with regard to an act relatable to an offense under this act, the evidence showed that the appellant was in constructive possession of the seized contraband as he had hired the vehicle for transporting the contraband. He submits that the same has been stated by the co-accused who had been acquitted by the learned trial court. By the co-accused, who was the driver, correct, driver of the abandoned car, and who had been acquitted by the learned trial. He submits that as there is no infirmity with the impugned judgment and order passed by the learned trial court, the same should be upheld. We have heard the learned counsel for the parties. We'll do the any concluded judgment reserved. You need to have a lot of, you need to train the police and there's some glaring lacunas.
for hearing item number 20.
Please, your lordships, lordship and the petitioner appearing in person.
Yes, what is this matter?
Lordship, this matter is through this petition, lordship. The petitioner, I'm not seeking any new policy for drafting of new policy, but to effectively implement the act, the scheme, which is being framed for the protection of for the welfare of women and children, lordship. Now, lordship, if I would this scheme is already implemented, lordship. The scheme is Janani Shishu Suraksha Karyakram, lordship, where there are certain entitlements where the scheme is looking at providing free of cost treatment for the pregnant women from the time of pregnancy, that is antenatal care, till during the time of child delivery, and postnatal care, lordship. And also, not only that, this scheme also is providing free services for treatment of newborn babies, lordship. From initially, it was for a period of 30 days. Post childbirth, if there is any complication, lordship, but this has been extended to 1 year, lordship. So the entitlements in briefs are, lordship, for a pregnant woman, it is free and zero expenses during delivery, and for it covers both normal and cesarean section, lordship. Then free drugs and consumables, then free essential diagnostics, which includes blood, urine tests, and ultrasonography, etc. Free diet during stay in the health institution, up to 3 days for normal delivery and 7 days for cesarean section. Free provision of blood, free transport from home to health institutions, free transport between facilities in case of referral, drop back from institutions to home after 48 hours stay, exemption from all kinds of
Yes,
user charges,
okay,
lordship.
that is there, but so what is your issue?
The issue is that, lordship, in fact, there was a PIL which was filed, lordship, and this court, lordship, yes.
Yes. What to do?
There was a PIL earlier filed before this Honorable Court Lordship. Actually, can come to page 78 of the appeal memo. If your Lordship remember, it was your Lordship judgment.
Oh. How would I remember?
Yes, Lordship, it is been. It was to 78, Annexure 6.
Where is the? Operative portion?
Also, the can you come to page 83? Paragraph 11.
Yes.
Let me start from paragraph 9. It is about the interpretation of the notification issued by the government of Nagaland Lordship with regard to the implementation of the Jesus case scheme. The 14 factor also shows the entitlement of pregnant women as single born babies under the Jesus scheme. The notification also shows that there is a grievance redressal mechanism in district and law officer who are to take up grievances of those targeted persons who have not been given their entitlement as per the Jesus case scheme. Serial number 3 and 4 of the guide grievance redressal mechanism as reflected in the notification is reproduced below. 3. Grievance redressal authority / model officer. A. The joint director, RCH, MH, as the state model officer. B. The deputy chief medical officer as the district model officer. 4. Action on grievance within 2 days and will be communicated to the company within the same time frame. The above serial number 3 and 4 shows that in even the pregnant sick newborn baby provided the entitlement under the JSSK scheme, the affected person can approach the deputy chief medical officer of the concerned district with the grievances. The district deputy chief medical officer shall then take action on the grievances within 2 days from the receipt of the same. In line with the above, the claim of the affected person examined by the deputy chief medical officer within 2 days, and if the chief medical officer finds that the affected person is entitled to the benefit of the JSSK scheme, the same should be given to the affected person within the week after taking a decision on the demands of the affected person. If the affected person is aggrieved by the decision of the deputy chief medical officer, the affected person can subsequently approach the joint director RCH, who is the state medical officer. The respondent number 6 should also ensure that the approved annual budget of the JSSK scheme should be released to the state government in time. That respondent number 6 is the Union of India Lordship. The state government respondent are also directed to give widespread publicity of the JSS scheme in length and breadth of the state and to implement the same in all letter and spirit. With the above observation and direction, the petition is accordingly disposed of. Now, based on the direction of this Honorable Court Lordship, the department has issued notification to all the districts to implement the scheme and to see the grievances if somebody is not paid. At page 13, Annexure D. This notification dated 21 August 2019. Immediately on receipt of the order of the Honorable Court Lordship.
Yes.
I may be allowed to read, Lordship. Yes. Notification dated 21st August 2019. In pursuance to the Honorable Gauhati High Court Kohima Bench judgment order dated 27/5/2019, attention is hereby invited on implementation of the JSSK scheme in the state that in the event the pregnant woman and sick newborn babies are not provided the entitlement under the JSSK scheme in any of the health unit, the affected person can approach the deputy. Page 13. My apologies. Notification dated 21. Yes. In pursuance with the Honorable High Court, the Gauhati High Court Kohima Bench judgment order dated 27/5/2019, attention is hereby invited on implementation of the JSS scheme in the state that in event the pregnant woman and the sick newborn baby are not provided their entitlement under the JSSK scheme in any of the health units, the affected person can approach the deputy chief medical officer, who shall then take action on the grievance within 2 days from receipt of the same. In line with the above, the claim of the affected person shall be examined by the Deputy Chief Medical Officer within 2 days, and if the Deputy Chief Medical Officer finds that the affected person is entitled to the benefit of the JSS scheme, the same shall be given to the affected person within a week, after taking a decision on the grievance of the affected person. If the affected person is aggrieved by the decision of the Deputy Chief Medical Officer of the concerned district, the affected person can subsequently approach Joint Director RCH, who is the nodal officer. The FMG SPMU shall ensure that the approved annual budget in JSSK scheme are released on priority basis to the health units. But based on the Lordship, the scheme, now Lordship, whatever we receive from the Government of India, the entitlement of a pregnant woman and a newborn baby, Lordship, we provide that by way of referral transport, that is providing ambulance service from the resident of the pregnant woman to the health unit and vice versa, Lordship. And that's for diet when they are admitted there in the hospital. Medicines, all the medicines that is provided in the government hospitals or health units are free of cost. We don't charge. But to ensure and to implement the order of this Honorable Court, Lordship, specific direction has been given to the districts and even the finance management group, the FMG, the last paragraph, Lordship, have been directed that the fund should be allocated to the health unit in time, on priority, so that nobody is deprived of their entitlement. That is the pregnant mother and the newborn baby. Now, as far as the entitlement, the rate is concerned, Lordship.
Yeah, are you getting the funds from the union?
Funds, Lordship, as per our placement, we give, Lordship.
Now, are they giving you the funds?
Yes, fund has been released, Lordship.
Then what is the problem in the PI? Because the court finds it difficult.
Lordship.
Here there is already a division bench judgment.
Yes, Lordship.
To the effect that if a person is aggrieved
Yes.
for not getting the benefits, he can very well approach.
Yes, Lordship.
And thereupon, then also, if it is, whether it is given or not, you are saying that you are giving.
Yes, Lordship.
Now, has the petitioners made out any case out here to the effect that they have approached in
No.
terms of the judgment?
No instances.
And if not, why should we
Lordship,
entertain the
now the
PL
issue
matter?
is this, Lordship. The issue raised in this petition is this. Now the judgment is very clear that the scheme has to be implemented in all letter and spirit. Now what happened, as soon as the judgment was passed, the state respondents have come up with a notification putting a ceiling on the benefits, Lordship. Lordship is in page number 85, Lordship. Page 85 of the main petition. This is the aggrieved portion, Lordship. 85, 85 and 86, Lordship. Now they have, under the Janani, there are two schemes which they have highlighted, with the Janani Suraksha Yojana, which I'm not concerned about. Now I'm concerned about the Janani Shishu Suraksha portion, where the limit has been kept for drugs and consumable worth up to rupees 350 per pregnant woman only.
200.
Yes, 350 for normal delivery and 1,600 for C-section. Then diagnostic worth up to rupees 200 only. Now, if a patient wants to go for ultrasound is mandatory, Lordship, in all trimesters of the pregnancy, Lordship. Now, 200 rupees doesn't cover it, Lordship, just for one ultrasound, Lordship.
No, what is the union giving? What is, as per
So,
the,
Lordship,
yes,
I will come to the
rate of
Lordship.
union.
The union's affidavit is very clear, Lordship, which also concur with the grievances raised in the petition. They don't deny, Lordship. Now the scheme says that all this has to be for free, but putting a ceiling makes no sense, Lordship. There's an inflation also with the passing of time. The rate of medicines and diagnostic services is also increasing, Lordship. And now coming to the blood transfusion, the ceiling is only rupees 300 for blood transfusion, which is very. Then again, Lordship, diet, rupees 100 per day, up to 3 days. Then rupees 100 for per day for the covering only 3 days for the normal delivery and 7 days for the C-section, Lordship. Now coming to the referral transport, Lordship, from home to facility, rupees 500. Then a facility to home, it's facility to facility, rupees 500. And in case of facility to home, drop back, that is 500, Lordship. Now, for example, Lordship, just there's an increase in the rate of taxis also. Now, my concern is about those people located in the remote areas, Lordship, which taxis is very scarce, Lordship. Now, if they have to hire, they spend at least, Lordship, more than 10,000, Lordship, from a remote location to the facility,
Okay, so
hospital, Lordship.
what was the central guidelines?
Central government, the guidelines said it is free, Lordship. It is free. All the services are supposed to be for free, Lordship.
Where is that, madam?
Lordship, the scheme is very clear, Lordship. It's in page number
43?
Lordship, can you see the affidavit of the union, paragraph 6?
The
It has been
guideline starts
explained.
on page number 39, Lordship.
Union of India.
Now the relevant portions. This is the scheme.
That is the guideline, Lordship.
This is, yes, according to this guideline, the scheme is implemented, is to be implemented.
Now, who is going to pay them amount?
That is the central government, Lordship. Now, if we, interestingly, if we look at it's a few pages of affidavit filed by the central
Madam,
government.
let us see the guideline. What are the things which is given as per the
Yes,
guideline?
Lordship.
Yes.
Lordship, the relevant portion is, it's quite lengthy, Lordship.
Which page,
Page number, starting from page number 45. The introductions and the other portions starts from page 39, Lordship.
So does it give any rate?
No rate, Lordship. It says
No
free
rate.
of cost, Lordships.
Now, is the center providing all the benefits? Is reimbursing the entire amount? Because your affidavit is not clear on that aspect.
So they're basically the entire, this under this scheme, 100% payment is being made by the centers.
No, it's 90-10.
How can it be 90-10? This is not a CSS or a NLC. How can it be?
It's a centrally sponsored scheme. Now, Lordship, what happens is the state, it comes under the National Health Mission. Now, what happens is every financial year, for the financial year, the state put up a proposal for budget, requisitioning budget. Then the central accordingly sanctions, Lordship, approves and sanctions. Now, if you look at the affidavit of the Union, Lordship, which is just filed very recently on 19th September
Mr. Yangavati,
2023.
you have filed the affidavit. Kindly come to paragraph 6 of your affidavit.
Yes, sir.
The fund being approved under the JSSK is based on a unit cost per beneficiary which has been calculated at the level of the government of India. Now, what is that? What have you calculated? Why have you not mentioned that? Now, is it in consonance to what the government of Nagaland is giving or not? Because if it is your scheme, why should the Nagaland is only the implementing authority? Well, that is as per your affidavit. So what is the cost factor per unit?
No, it's not that. You see, when you give the money, it has to be based on some parameters. And as per your para 6, what my brother is saying, your para 6 seems to indicate that these funds are made on a unit cost per benefit, based on a unit cost per beneficiary. So it is based on some parameter calculated by the government of India. So that now we want to see whether the cost that has been calculated by you is similar to the cost calculated by the government of Nagaland. Why, or if the Nagaland government is giving a lesser amount than what is being given by you, where is that money going first of all? Now, so we want you to bring out this, clarify this para 6.
Lordship, can we come? Since our affidavit was filed way back in 2020, Lordship, we have placed our requirement, that is the rate given by the government of India to us, Lordship.
Where is that government of India rate given to you?
Yes, Lordship. I would like to draw your Lordship attention to page 8 of my affidavit, Lordship. Yes. For every financial year, the rate given by the government of India, that this is the proposed rate of government of India to the state, whether that is acceptable to the state. And we agree to this rate. And we send RPIP, plan implementation plans. This is our requirement. So the chart up to financial year 2020,
Page,
page 8 of my affidavit.
affidavit of respondent 1 to 4.
1 to 4.
Page 8.
Because you asked for 2,000 for C-section,
Yes,
for
Lordship.
cesarean,
Yes,
and they gave you 1,600.
yes, Lordship.
And you are giving how much as per your rate?
The rate, Lordship, that has been shown by my learned friend in the chart.
Yes, that is around much less than that.
But Lordship, whatever has been received by us, approved by the government of India. So we have notified in page 85.
No, let us be very clear.
Lordship. Because we place our requirement to the government of India.
Just a minute.
Taking consideration of the topography, Lordship, the accessibility to the health units, we give our placement. But whatever is given by the government of India to us, Lordship, we give to the
But
beneficiary.
Mr. Modi, can you understand one thing? Understood, 2014-15 rupees 100 would be sufficient for
Yes,
per,
Lordship.
per day. But how are you maintaining the same for till now?
No, Lordship, the rate that is given by
No,
the
no,
government-
that is,
Yes.
this is, yes, initially the rate was, you asked for 500 and they gave you 100 per day. This was in 2014-15.
14, yes.
This is on based upon your proposal.
Yes.
Now, why are you maintaining the same proposal from 2014 onwards? Is the cost of living not going up?
No, Lordship, the thing is that we make our placement. Now, Lordship, I would like to draw your Lordship attention to my next annexure, page 9. The mail sent by us, because now they have increased the rate. This is in 2020, Lordship.
Page 9.
Yes, this is the existing budget under the JSSK, under different head, different components, Lordship. Drugs and consumable for normal delivery, the existing rate was 350. So they have asked for the revised rate to us.
So they have asked you for
Yes,
giving
yes.
more.
Now,
What have you
after,
done?
yes, after that, Lordship, since our affidavit was filed after that, at that point of time, the latest one I don't have with me.
But now.
But it has increased, Lordship.
Give us
And
a-
Lordship, there is no instance of any complaint from the health unit with regard to non-payment of the entitlement.
No, madam's grievance is limited, that the amount which you are given is
Yes.
not proportionate or to the what, or does not commensurate with what is the actual expenses.
Yes. Now,
That's
Lordship, the amount given, it's not that cash will be given to them. They are entitled up to that amount medicines, up to 300.
Transport of.
Because whatever medicines we are getting, Lordship, we are buying, that is given to the patient. And these are
What about the transport?
Transport ambulances are there, Lordship, in health units.
And food,
Food is given in the health unit
100 rupees
per day, per patient is entitled, up to 100 rupees per food.
for till 7 days.
Yes.
So you give food nowadays.
Yes,
Okay, diagnostic.
Lordship.
What do you understand by the word diagnostic? 100 rupees, 100 per sick infant.
That is for the normal
And 200
examination
for,
of the patients. Normal
and
examination of the patient.
normal examination.
Yeah, sure.
So ultrasound and all are not included.
Lordship, we don't have ultrasound in sub-centers and remote areas, Lordship.
Okay, supposing.
Yes,
So this
we
is-
have in district hospitals.
So this JSSK
Lordship.
is only for the rural areas, is it?
No, Lordship, it covers
No,
the whole
so that
area.
is why, that
Yes.
is why.
But only in the public health
No, that is
institution.
why I'm asking. Is this JSSK only applicable to rural areas or even to the urban areas?
Now it has covered urban areas, Lordship.
If it covers urban areas,
Lordship.
is this ultrasound is necessary or not necessary? Have you asked for ultrasound?
No, Lordship, if there's a cases of complication and reference from the health units to the district hospital, ambulances are provided. The patient is transported to the health facilities where they have the equipments.
That is not true.
How many ambulances do you have?
They have not many allegation that we have not done it, Lordship. We refer patients from the rural area to the urban district.
How many ambulances do you have in the various sub-districts of Nagaland?
Lordship, depending on the catchment, the population, Lordship.
So I think we need some more materials. First of all,
Yes.
we need the new rates that you have proposed to the
Lordship,
center.
Lordship.
You have already proposed, you said.
Yes, we have.
Has it been accepted?
Lordship, that I have to check out with the department.
Please bring the forwarding letter. When did you send the proposal?
Yes, Lordship, I can do that. Lordship. Because, Lordship, our case.
Have you also stated in your affidavit That you don't pay in cash, but in kind? Means, actually you give the services.
We have not specifically stated, but we have said this is the entitlement, the rate up to 300 rupees, suppose lordship, for a particular component. Free of cost.
How do you do that?
Lordship, for food.
Just
food
for
is-
example,
Lordship,
you are giving it here 100 rupees for the purpose of transportation, or 500 rupees.
500, yes.
A person whose distance will be around 10 kilometers or 15 kilometers out there.
Lordship.
So how do you do it with
Lordship,
500
the fuel,
rupees?
fuel is purchased for that purpose because the ambulance is going to be used to transport the.
So how do you give the fuel?
Lordship, that is paid to the health unit where they are operating.
They give coupons.
No, Lordship, the fund is allocated to different health unit.
Understood, but how do a person gets the transportation cost?
Lordship,
If
that
you are
is-
not in a
that
position.
is not paid to the patient. That amount that is earmarked for patient from one health unit to the resident of the pregnant woman, that amount is used to buy the fuel to transport the.
So you.
They're saying that we get 500 per fuel, Lordship. That is not the.
No. So
that's not the scheme.
So therefore, it is have you taken up the responsibility to bring them from that place to your place? To
Yes,
that-
because there are ASHA workers in the blocks.
But
The ASHA
Mr.
worker-
Muza, have you
Lordship.
put these in your affidavit?
No, Lordship, that.
Because that is a very important aspect. If you are doing it in, therefore I'm saying, are you doing it for in kind?
Yes.
Against that amount?
Yes, because what I see is that the petitioner is going beyond what is being asked in the
No,
PIL.
no, it's not that. You see, this is a PIL. We
Lordship.
can go beyond.
Lordship.
That's not an issue.
They are talking about the city.
Okay. Miss, yes, petitioner, anything else? No, you see, one thing is that it appears that we cannot finish today because we need some more information from them. First of all, very important thing is that Mr. Mazui, you have said that you pay in kind. We're going to record that. And we want an affidavit saying that you pay in kind.
Lordship.
And,
Wherever cash is entitled, we give cash. Because under GST, yes.
Then one has to make it very clear on this affidavit. If you make it in cash.
You
and all-
cannot, you cannot have your cake and eat it too. You've got to be very clear.
Lordship.
Okay, you give your affidavit, wherever you pay, cash you pay, but
Yes.
give us the parameters under how you decide whether
Yes.
to pay cash or to pay in kind. And
Yes,
why do
Lordship.
you do that?
Lordship, if I will be given time to file an affidavit with regard to how the scheme has been implemented in question of payment, Lordship. I'll get information and then the rate that we have proposed and what rate we are receiving from Government of India. Because as I've stated in my affidavit, we are totally dependent on the Government of India as far as the scheme is concerned. Whatever rate is given to us, we give to the beneficiaries.
Supposed to be given,
Yes, Lordship.
actual giving, whether it's in kind or cash.
Lordship,
you'll have
yes,
to
yes,
justify
yes,
that.
Lordship, yes.
Lordship, if all may not be possible, but just the recent receipts, which they have given, if they can also be produced as a proof, Lordship.
For the rural areas.
Lordship.
Okay, you maybe for one subdivision or something, you cannot ask for the entire state.
Just the recent Lordships. Maybe for the last 3 months, Lordships.
Madam, first let us look into the affidavit, what they say, how
Yes.
they pay, make the payment.
Yes.
And what is the new proposal? Because your thing is that the amount which is there, although it is there, but that is not, doesn't commensurate with the actual cost.
Exactly.
Now,
Lordship.
he says that the question of money is not there. We sometimes give it, we bring them out there and pay for the fuel. Let us hear as to, because that is not a part of the affidavit.
Lordship.
And also what they have proposed, because the government of India asked them into year 2020 itself as to this was the rate existing, how much are you proposing? And we are in 2023 at that in the fag end.
Yes,
So
Your
let's have it.
Because even in 2020,
I think what will be for one subcenter, we'll ask them for maybe 2 months receipt. You give me a name, one subcenter. Which subcenter? We cannot ask for the entire state.
Yes, Lordship.
because we spend more time in collecting data for the PIL.
No, but you see, sometimes it's good, sometimes of course it's a waste of
Lordship,
time.
yes, definitely, I do agree, Lordship.
So like, look, there was a letter from the government of India in 2020
Lordship,
for you to make a proposal
yes, Lordship.
for change of rate, and it appears that you have not done so.
Lordship, when the affidavit was
Because your
filed,
affidavit doesn't
that-
say about it.
that proposal was sent to us. This is the existing rate. So what enhancement do you want? This
then-
was asked
but
from
then-
us. So that time we have filed the affidavit in 2020, Lordship.
Lordship,
Now we are in
sir.
2030. To check out with the 3 years, how much it has increased,
Okay,
Lordship.
right.
Lordship, normally in subcenters, there is hardly cases of delivery. So Lordship, if this can be records from Mon District Hospital, will be produced, Lordship.
You're right.
Lordship, why not Kohima? Because Kohima is nearest. We can get information at the earliest, Lordship. Sending to Mon, Lordship, and getting information from there, Lordship.
You are going to get information from there anytime anyway. How does it
No,
matter?
we can get it, Lordship. But what I'm proposing is Kohima is here only.
No, we-
Because deliveries are done here from nearby villages. If there's any complication in delivery, it's brought to Kohima district, NHK, Naga Hospital Authority, Kohima.
Is it that Mr. Mojoy wants a peaceful winter vacation?
No, Lordship, it's not that, Lordship.
Because this matter is obviously going to come up after the winter.
Yes,
recess. So you have enough time.
Yes.
Sufficient time can be given to
Yes,
the.
if enough time is given to me,
respondents,
I can get information, Lordship. Yes, I do agree, Lordship.
Correct. Read Miss Nityo Koza Learner Council for the petitioner. Miss Nityo Koza petitioner in person. And Mr. N. Mazui, Learned Council for the respondent number 4. 128.
Yes.
Mr. Gauhati appears for, Learned CGC appears for respondent number 5. Okay. Acha, 1 to 3.
1, 2, 3, and 4, sorry.
1 to 4.
Yes.
And, while hearing the submissions of the parties, Mr. N. Mazui has stated, has submitted that the submitted that the entitlements approved by the entitlements paid to the pregnant women and their children under the JSSK scheme in terms of the notification dated 24/6/2019 are sometimes given in cash and sometimes given in kind. The respondents number 1 to 4 shall file an affidavit stating the same. and the manner and parameters and the manner in which they decide as to whether, as to how, as to whether a person should be given the entitlements in kind or in cash. It is also noticed that in the letter dated 18/6/2020 issued by the Joint Commissioner bracket MH by close Ministry of Health and Family Welfare, Government of India, that the state governments have been asked to suggest changes in the entitlements as shown in the said letter. In respect of the particulars shown in the said letter dated 18/6/2020, which is at page, which is annexure B to the affidavit in opposition filed by the respondents number 1 to 4. Mr. N. Murray, learned counsel for the respondents number 1 to 4 submits that he will obtain instruction as to whether the state government has suggested changes to the entitlement of pregnant women and their children in response to the above letter dated 18/6/2020, and the status of the proposal made by the state government, if any. The same should also be incorporated in the affidavit, additional affidavit to be filed.
Lordship. Lordship, including the latest financial year.
It should be the latest. The Mr. N. Murray shall also, further, if any new entitlement has been made subsequent to the request made in the letter dated 18/6/2020, the same should also be provided in the additional affidavit to be filed by the respondents number 1 before.
Lordship.
Then, next para. Para 6 of the affidavit in opposition filed by the respondent number 5. UOI states as follows. The funds being approved under JSSK is based on a unit cost per beneficiary, which has been calculated at the level of GOI. The Mr. Yangarwati CGC shall obtain the instructions and produce documents showing the basis for showing the
CGC shall obtain the instructions and produce the documents.
and shall obtain instruction and submit an affidavit showing the unit cost per beneficiary, under which has been made by the JSSK, which has been made by the state central government for the JSSK, and the manner in which the same has been calculated. Next one. In view of the issue raised by the petitioner with regard to the entitlements to be given to the pregnant woman and their child under the JSSK scheme, the respondents number 1 to 4 shall also state in their affidavit, shall also state in their affidavit the expenditure for entitlements under the JSS scheme for the month of
paper. For the month of October and November 2023. For the month of October and November 2023. In respect of the district, in respect of the district hospital. In respect of one district hospital. The affidavit should clarify as to the expenditure incurred for giving the entitlements by way of cash and by way of.
Mr. Mojoy, would it be district hospital or district? One district.
It's district hospital more.
District hospital. This is the matter after sometime.
Because I have to get information, then I have to prepare affidavit.
After vacation, Lordships.
This is the
There's
matter on
sufficient time.
19th January.
Lordships.
Lordship, 19th January.
You are opening on 15th.
Lordship. So at least Lordship, because I have to get information, then I have to cross-check with the information that they have given me, Lordship.
Okay.
Because I cannot find an
Okay,
affidavit.
25th, 24th January. 24th January. Yes. Yes.
My lord, I beg to mention item number 25.
Yes.
Apologies for the delay.
Yes.
I've just received a copy of that appeal. I'm the respondent.
Okay.
Therefore, kindly grant me some 2 weeks time.
Okay. Okay. For hearing.
Yes,
There's no question of affidavit being filed. This is an
Yes,
appeal.
kindly grant me time for hearing.
Okay, right. Mr.
A. Sophie. A. Sophie.
A. Sophie appearing for the respondent number
1.
one submits that he has received a copy of the appeal today and needs some time to peruse the same. He accordingly feels that the matter may be heard on another day. Ms. So-and-so
Make up.
appearing for the appellant submits that she has got no objection to the same. Accordingly, I'll leave this matter for hearing after how much time?
2 weeks, madam.
After 3 weeks.
Lordship, there is an interim, Lordship.
Interim order to continue till the.
Much obliged, Lordship.
So there will not be any DB, I think, now, because I've got.
Lordship,
This is the matter you want.
Lordship, in case we have one matter also, item 23.
Okay, what is
But,
that? What is the matter about?
Lordship, here the petitioner is challenging the service of the home guards, Lordship. If there's a possibility of them,
I've already fixed some matter.
Lordship, then next week, Lordship.
Next week.
Yes.
And it wait the winter recess.
We've already fixed three matters, I think, 3-4 matters. So he's going to be busy. I'm not going to be here. So
Lordship, we have mentioned, Lordship.
unfortunately, I had fixed some matters. I didn't know that DB was held only on Wednesday. But we're changing it. We're having tomorrow one day after.
We'll fix a date immediately after vacation.
Lordship, after vacation.
Okay, right. This matter after the vacation. Item 23.
23, Lordship. Much obliged.
Item number 21.
Yes.
Let the matter become of next week.
Okay. Next week.
Lordship, if
I
in
don't know. Next week.
20?
21. Lordship.
Because we have already fixed some matters. Your matters are there. Because DB might be sitting only on Thursday.
Lordship, this matter cannot be before Justice Kohima. Lordship, if you can accommodate meet tomorrow.
What is the matter about?
Regarding our appointment reservation, saying that the
Reservation?
Lordship, that's since the respondent is not a not a indigenous, that is the issue. Lordship. And
It will take time.
it
relates to grade 3 appointment, Your Lordship. Yes, the respondent was appointed. However, basing on the ground that the appellant is a landowner and that the respondent is not an indigenous inhabitant, her appointment was challenged.
Okay.
This is almost in complete authority of my lordship.
Okay, we'll try for tomorrow. I don't know. Let's try. Yeah, this is the matter tomorrow.
Bless.
Huh? 22 is remaining. Who is 22? State of Nagaland. What is this matter? This is after vacation. What is the matter?
I'm not into this case, my lord.
Okay. So we
This
we-
matter come after vacation, my lord.
Regularization and scale of fees both.
Regularization, scale of stay.
State is the challenge. This single bench judgment in order.
Who's judgment on it? Okay. Regularization and scale of stay. Okay. Actually, where is the council? We're not here. Also.
It's just here.
Okay, we'll see tomorrow. It's here the council. And okay, this is the matter after the king.
Okay.
Because actually we are also pressed for time.
No.
Much obliged.
May I please, Your Lordship? My Lord, as per the direction, Honorable Court direction, Principal Director is here. my lord.
Okay.
So preference may be given to hear the matter.
Yes, yes, we'll hear it.
Yes.
Item, item 4.
Yes.
For hearing, item number 4.
Yes, Lordship. Lordship, my Lordship. We have brought the records in original as directed by the song.
Let me see that.
Yes, Lordship.
Let me see the concerned.
Yes, Lordship. It's in original. The fact.
Where is the petitioner's counsel?
Which one?
With Joshua.
He has some, objections, so he has.
The first page, Lordship. We have flagged it. The first, that is the letter, 10 June 2021.
This is not the original. How can it be? It's overwritten straight away.
Lordship, that is only the record we have, Lordship. Lordship, if I may, Lordship, before the principal director speaks, we apologize for the way the file was maintained by the establishment branch, Lordship, of the nursing section. But Lordship, the correction was made basing on the letter written on 10. Lordship, can you see the letter? The first letter. This was the benefit in place. All the controlling officers, all the A&M and FSWs were posted, Lordship, for objection claim with regard to their seniority. So 30 days was given, Lordship, which was circulated all over the state, Lordship.
No, you see, you please show me
Lordship.
your seniority list as on,
That's 2050.
huh?
The one that is in the writ petition.
The one in the writ petition, show me that.
Yes.
No, you don't have it here in the records. The one in the writ petition.
Lordship, we have just brought, it's there, Lordship, but we have just flagged only the 2000.
No, please give it back.
We are not disputing the 2020, that is annexed in the writ petition, Lordship.
You're not disputing this.
Lordship. Because the correction was made basing on the service record, the service book, and the appointment order of the petitioners, Lordship.
Where have you stated that?
Lordship, that we have not stated, Lordship.
Then?
Because
You have made correction on what basis you said?
on the service records, the appointment orders, Lordship. It was wrongly entered in 2020.
On the basis of
The service record,
service record,
the appointment orders, Lordship,
appointment orders,
of
and
the petitioners. Service book, Lordship, the service book.
Now, can you make plead or make submissions beyond your pleadings? What is the law?
Lordship, we tender our apology, Lordship, because this is as per the record maintained by the section. And Lordship, accordingly, the release orders were issued to the petitioners. And they have accepted it. And they are fully aware of their release order, Lordship. They have not challenged this, Lordship, in the writ petition. Lordship, may kindly come to the first page. This is dated 18 February 2022. Signed on 18 February, issued on 21st February. The next page, Lordship, the next page.
Yes.
Issued on 21st February, but signed on 18th, Lordship. Lordship, may kindly come serial number 1.
Yes.
Serial number 1.
Have you got a copy for her?
Yes.
Please give her a copy. Yes.
The petitioner number 6 is serial number 1 in the first release order. P. Aseno Lota. She was released with effect from 13.
No, the petition number 1 is Nikono.
Nikono, Lordship, will find in serial number 4. Serial, yes. Serial number 4, Lordship.
Yes.
She was released the last column, Lordship, completion of 35 years of service, completion of 6 years. Because Nagaland, we have got a particular system of retirement, Lordship, 35 or 60. So, serial number 4, Nike Henyo, she was released on 31/5/2022.
Thirty-one
22. Serial number 4. And the list that we have submitted before this honorable court lordship on 4th of December.
Just a minute.
Yes.
Yeah. This is the original or
No, it's Xerox
photocopy?
copy, lordship. It's not allowed. If needed, we can produce the original also, lordship. Nicolino is serial number 4, lordship.
Serial number 1 in the
Petitioner number 1 is serial number.
petition, the petition number 1, correct?
Yes, lordship. Petitioner number 1.
Then
Petitioner
this-
number. Petitioner number 2 is lordship will find in the 3rd page of the release order, lordship.
is the petition number 2 not here in this page 2?
No, a different release order has been issued, lordship, because petitioner number 2 retired with effect from 30/6/2022. As per the service book.
So he was there in the
Yes.
in the list.
Yes.
Petition number 2. Then
She put a benefit, yeah. And she has been given the benefit of the
I know, I
application.
know.
Yes.
Show me petition number 3.
Petitioner number 3, lordship, Narotula is at the next page, lordship, 4th page, serial number 2.
Petition number 3.
Yes, lordship.
And petition number 4.
Petitioner number 4. Serial number 1 of the same page, lordship.
Petition number 5.
Next page, lordship, the last page, serial number 1.
Timsu Kumla.
Yes, Tamsa Kamla.
Petition number 5.
Yes. Petitioner number 6 is P. Asino Lotha. The first page, lordship, serial number 1.
Petitioner number
6.
Petition number 7.
Inti.
Last page.
Inti Merenla. Yes, last page, serial number 2, lordship.
Petition number 8.
Lordship. Yes, serial number 3, first page, lordship.
Serial number 3. Petition number?
Petitioner number 8. Petitioner number 9, Savino, lordship. Serial number 5 is the same page, first page.
Yes. Petition number 9. That's all.
Yeah, petition number 10, Viti Pile. Serial number 2 of the first page.
Petition number
2. Yes. So they were released from service as per the service book report, lordship. The mistake we have committed, lordship, I tender my sincere apology, lordship, is that the manner in which the records were maintained, lordship. Because we did not want to have the issue of overstay, lordship. So the things were done in very haphazard manner, lordship. We admit our fault, lordship.
No, you're at fault because
Yes, lordship.
how can you change their date of retirement without issuing notice to them in the first place?
And lordship,
You are admitting.
lordship.
You are admitting the seniority list as on January 2020.
Yes, lordship.
Now you have changed the
Admitting
date
in
of
the sense, lordship, there was no complaint at that point.
no complaint. So you have so this is an admitted position, and so this is a valid document.
At that point of time.
It is always
Yes.
a valid document.
Yes.
Now that has been now superseded by
Lordship,
this
2021.
without giving them notice.
Lordship,
Because it prejudices them, they're going to retire 1 month earlier.
Lordship. Yes, we admit that. Lordship.
Ah,
We
So this cannot stand.
No, Lordship, yes, Lordship, admitting the Lordship, what the Lordship has made an
Naturally,
observation. Yes,
naturally, as per
yes,
the
yes,
principles of natural justice,
yes, Lordship,
when
definitely.
when you pass an order
Definitely,
which prejudices someone,
definitely. Lordship.
you are duty bound to give them notice.
Yes,
You're
Lordship.
not, you have not nowhere given any indication that this has been changed for this reason or that reason.
Yes, that
Where is
reason
that?
we have not given. We admit that, Lordship. But the Lordship, the issue is this, Lordship. After that, Lordship, there has been administrative oversight on the part of the department in not giving them notice, Lordship, with regard to the change in the date of retirement, Lordship. However, Lordship, the fact remains, the petitioners are well aware they have already accepted their release order, Lordship, and they have not challenged in the present writ petition. And this is February 2022 release order, Lordship.
No, Mr. These orders
Yes, Lordship.
were February 22. Okay,
And the-
prior to the. Yes, madam, what do you say?
Lordship,
1810, they filed in October. They've already released one service. Lordship. They were aware. They are aware of it. Lordship, the mistake is on our part.
Now, whether they were given these copies of this.
Yes, they are given. They are aware of it, Lordship. They are aware. They're fully aware, Lordship.
Anyway, let me hear.
Yes.
Lordship, we have annexed all the documents that we are familiar with. As per the documents, this is the only documents that we have. So we have annexed all this. Otherwise, Lordship, we were not aware of this.
Because as per this document, now they seem to have a point. Only thing is that they have not given reasons for it.
In fact, there were no legitimate expectation because they were retiring as per the seniority list and the records, Lordship. They were expecting that, and even now they were saying that they were releasing on 36/22, Lordship.
Let's see the records where it shows that you have given them copy of this.
Lordship, that consent file is not here with us, Lordship, in my opinion. Lordship, but we can produce tomorrow, Lordship. Because as per the court order.
When is your senior coming? You see, Mr. Principal Director.
Yes.
You see, the thing is that there is a seniority list of 2020. Now, during the argument hearing, your lawyer brings out the seniority list of 2021, which is not same as the 2020 list. And it is very clearly seen that numbers given in the 2021 seniority list is not typed copy. It's by pen or pencil. It has been overwritten. So prima facie, even when you look at it with the naked eye, it shows that there has been manipulation. If you want to make a correct copy, type it out and print it out. Why make it in pencil? It is very clear. Now, there is nothing stated by you that you have changed this on the basis of their service record. Now, let us see the service record. You have to give reasons for changing the date. Where is the service record of this person?
It's with the petitioner, sir.
How can it be with the service?
Lordship, they have already do this. Now they have to process for pension.
Have you got the service book?
No, we don't have.
No. You see, I don't know how the system works here. You're not supposed to have they're not supposed to have the service book. You're supposed to make the pension papers. The pension proposal
Yes,
should come from the department, not from
Yes,
the individual.
It's released to them, Lordship. They prepared everything, documents, and then it's submitted to us.
How come? How can it be done?
And then
They
it's
can. No. That's the wrong thing. I think you just talk to your clients. I don't think that's the right way. They'll change the. Yes, tell me.
Lordship,
Yes,
regarding the
pension.
pension service pool, at the time of the retirement, the pension preparation is forwarded to the AG for clearance,
Correct.
and it will be retirees.
No, it should not be handed over to the retirees. What happens is the form is filled up by the petitioners, by the retiree pensioners. Form is filled up. The pension proposal is to be made by the department and then submitted to the AG. And AG will keep all those documents and accordingly approve the pension. And it should be sent back to you. Why should it be given to the petitioner? They'll change it. They will change their date of birth and whatnot. Then what happens? Another round of litigation. Why should they have it? I don't think that's the correct.
Lordship, I'm very much confident that the service book is in the
Hands of the
safe
petitioner.
custody with AG, because at the time of the processing of the petition paper, it is with the AG is the custodian.
Problem now is what they've done is wrong. That much I am very sure. Because no notice was issued to you.
Yes, Lordship.
But on the other hand, if what they say is correct, then I would be passing a wrong order. Because I'll have to see if your service book and the date of retirement matches.
Yes.
So, in that way of the matter, I think best thing to do is, by way of abundant caution, is to ensure that why don't you call for the service book? They cannot call for the service book. You call for the service book because you had. Can you call for the service book from the AG's office, Mr. Principal Director? You can call for it, no? If you can call for it, then let us see it. And then if you say what is true out there,
No.
then we'll take the next step. Because you can give a post-decisional notice also, hearing to them. Because they need to be heard
Yes.
for changing their date of retirement.
Because as per our record, they have to retire.
But then you, where,
Yes, we have not.
where have you mentioned
Yes.
in any affidavit, it was your duty to mention to this court that the 2020 seniority list cannot be applied to this facts of the case because we have changed the date of retirement
I do admit that.
by a new seniority
Yes.
list in view of the records maintained in the service book and in the
Appointment orders.
appointment orders.
Yes,
That
Lordship.
is not
we
the-
admit, we admit, Lordship. We have not done that. Lordship. We
So
admit.
where are the appointment orders?
Lordship, if some time may be given, we can collect all these documents, Lordship. We can call for the service books from the AG. If the court can pass necessary direction to us, we can call for the service book of the petitioners, as well as we can produce all the original documents that we have.
When?
with us.
Next week? By Wednesday? By Wednesday?
Wednesday, Lordship. But, the issue would be coming from the AG office, Lordship. For us, we can give.
How does it matter? You are the cause of all this trouble. If you had given a proper affidavit,
Lordship, yes.
then we could have considered everything.
Yes, definitely, Lordship. That is our mistake. We apologize for that.
Now, at the time of final disposal, you come up with a document where there's overwriting.
Lordship. Maybe on Thursday. Lordship.
Thursday next, they'll be too busy, the division bench. We'll fix a number of matters. Mr. A. Tripapom is there, he knows. He's going to be very busy next Thursday.
Even me, I have gotten single mention before your court. I have got it on Thursday next week.
I am not here next week.
On Thursday.
I am not here next week.
Okay. But for the court. Lordship.
My brother will be here with Justice Shema.
Yes, Lordship.
So they are going to, so that is why I wanted to have his approval because he's going to sit. I'm going to sit only this week.
Lordship, regarding the appointment orders, Lordship, we have also annexed in our additional affidavits.
Oh, let us see. Let us see.
Page 9 of my edition. Lordship, affidavit in reply, my apologies.
Affidavit in?
Reply, Lordship. To the respondent number 2. Page 9, Lordship.
Page 9.
Lordship.
We have also mentioned in the release order, Lordship, date of joining service.
Okay, also mentioned there.
Yes, Lordship. Just before.
No,
the-
so let's compare.
Yeah, comparison for comparison.
Yes. So this is 27. Date of joining. This is date of joining.
Date of joining of in service.
Date of joining in service
Petitioner
is
number 1, Lordship, serial number 4,
1/6/87.
1987.
And out here, this is appointment order.
Yes.
No, date of birth, I think. Date of birth, what is it?
No, the second last column, Lordship. Second last column of the document that I have placed before. The loose sheet that I have.
Loose sheet?
The release order. The release order.
Ah.
I've given a copy of the release order.
This
Yes,
one?
the second last column.
Yes, second
It's the
last
date of
column.
joining service.
Yes, date of joining service.
The second last column. Lordship.
No, that,
Date of joining.
yours is date of joining. Yours is- So page 9, yes, I've got page 9, madam. Where?
9, that is appointment order, the common appointment, but there is no date of joining, Lordship. However, they have joined all the different dates.
So we'll have to see the date of joining, I think, because yours is actually not date of birth, it's 35 years, correct?
Lordship.
So we'll have to see the date of joining.
Yes.
So how do we know on what date? So they must have given some letter or something.
Joining report.
Joining report will be
Yes,
there.
because the joining report will be the date. Yeah.
So we'll have to see that.
Lordship will try to extract the joining.
Yes, you also try, they also will get it.
Yes.
Okay, both of you get it. And file all these documents by way of an affidavit.
Okay, Lordship. We'll do that.
This and the 21
Yes,
seniority
Lordship.
list,
Lordship.
you've got to make an addition.
Definitely.
I cannot dispose of this matter then. Though I was preparing to dispose of now because of these new facts, which might be true. If it's true, then your case goes. If it's not true, then we'll initiate.
Yes, Lordship.
We'll have to.
Because
they
we are
might have-
confident that, like, yes, this is their aspect. We do the calculation. Because in the 10 petitioners, 3 of them got the benefit because their entry was right. 2 of them got the benefit.
No, I've got no problem. The only thing is that.
Yes, Lordship.
The court should not be misled.
Yes, well.
That's the only thing
True.
that's paramount in my consideration.
True. Lordship.
Otherwise, I thought I'll initiate criminal action for misleading the court. But anyway, since seems plausible, though it's the fault, you should have mentioned in your affidavit that this 21 has been made. The seniority list of 21 has been made on the basis of the
Yes,
joining report and the and the service book. Okay, right. Third, Mr. N. Mazui, Learned Counsel for the third Miss
Mika
Mika.
Chay.
You got the name? Learned Counsel for the petitioner. Petitioner. Also heard Mr. N. Mazui, Learned Counsel for the Health and Family Welfare Department. Yes, sir. Mr. Your name? Project Principal Director? Dr. Is present in person with the records. Yes, sir. The order dated the order dated 4/12/23 is reproduced.
is reproduced here in below as follows. Take that. Next paragraph. The Mr. N. Mazui, the learned counsel for the respondent, submits that the seniority list of FHW supervisors as on June 2020 is a valid document, and they do not deny the veracity of the same. However, in view of the record maintained in respect of the petitioners in their service book and appointment orders, and keeping in view the appointment orders of the petition, keeping in view the joining report of the petitioners to their service, the state respondents had issued a fresh seniority list of supervisors, FHW supervisors as on June 2021. Wherein the petitioners number 1346 1346 and 9 were shown to be retiring on 31/5/2022 instead of the date of retirement shown in the seniority list as on
2020.
as on January 2020, wherein it was shown as, wherein their date of retirement was shown as 30/6/2022. He submits that the respondents have not made any pleadings in their affidavits to the effect that the correction in the seniority list had been made on the basis of the service book record and the joining report of the petitioner. Next one. He has also produced a release order number DH FW-4/22/ANM/RTD/2022 dated 18/2/22 issued by the Principal Director, Health and Family Welfare Department, wherein it shows that the petitioner's number 1346 and 9 were to retire on 31/5/2022. In view of them having completed 35 years of service. 35 years of service on 31/5/2022. As on 31/5/2022.
Yes. And also, Lordship, the third page also. It pertains to two petitioners.
No, it's okay. Acha, yes. Release order, wait, data. Release order number so dated 18/2/2022, comma, release order dated, release order
26
dated
26/4.
26/4/22 and 1/6/2022. So three. No. This is not required.
No, not
Sorry,
required.
1/6 is not required.
1/6 is not required.
26/4/2022. That's
Yes.
all. That's all.
The second release order is respect of petitioner number 4 and
Anyway, right. Yes, Para. The submission made by the learned counsel for the respondent clearly, no. You have also, the learned counsel for the respondent further submits that no notice was issued to the petitioners prior to changing their date of retirement as reflected in the service, in the seniority list as on 2021. As on June 2021. Full Next. The documents brought on record and the submissions made by the counsel for the respondents clearly show that there has been violation of the principles of natural justice while changing the date of retirement of the petitioners as reflected in the seniority list as on June 2021 vis-a-vis the seniority list made as of January 2020. However, the issue is as to whether the petitioners were to have retired on 31/5/2022, as has been stated by the respondents' counsel. So accordingly, this court requires, this court is to, it has to peruse the service book and the appointment and the joining report of the petitioners to ascertain as to their actual date of retirement. Accordingly, the Principal Director, Health and Family Welfare Department, and the petitioners shall endeavor to produce the service book of the petition, service book and joining report of the petitioners on the next court date. List this matter on when?
the last day she is focusing.
Which last day?
15th.
15?
This
This thing
last-
will happen. Huh? Huh?
12 Lordship.
13? No, you will not have DB on 13. And you might, because I don't know, might have also, but you'll have 14th also DB. That'll change. We have, you see, we're having DB tomorrow also, we're having DB day after. Okay, this is the matter on
Because the time is a bit short and then we have too many matter listed next week, Lordship. That is the issue. Because I also starting from Wednesday till Friday, I have a lot of these matters. Lordship.
Everyone busy.
Lordship. I leave it to your Lordship.
This is a matter on 14th.
Yes, we can try 14, Lordship. Yes.
This is a matter.
Lordship, the personal appearance of
The personal appearance of the principal director is dispensed with.
No, please.
You see, Mr. Principal Director, it's not that we want to call you. It's that it appeared that we were being misled. When there is an overwriting with pencil, and when there is, like today you all have said, that this seniority list has been made due to the records and this and that. Now, that seems plausible. That time there was no explanation as to why this sudden date change.
Yes.
One was 30 June, one was 31/5. Now, there should have been some explanation given by the council. Otherwise, when they don't give explanation as to why there is a change, then naturally it gives an implication that something is amiss, something is not right.
No.
So, for that, we have got to be serious and we have got to ensure that the court is not taken for a ride. Thank you for coming. So you have been given a copy of this release order, madam? You please check it.
Yes.
You have given, no? You have been given.
No, Lordship, yes, I've received.
And, so you just check. Because it appears if this is correct,
Lordship,
why didn't you complain earlier?
Lordship, if this is correct, we will.
And you have not challenged this.
Lordship, because.
Because maybe you are not given, we do not
Yes,
know.
Lordship. So we'll try to ascertain.
You
it,
try to
Lordship.
find.
They have collected also their own release order, as per information given to us by the section.
But there, so that is what, now it seems that the ball is in your court. Why have you not produced these documents in court? To show that you knew about this and you are hiding facts from the court. And if you are hiding facts from the court, then both of you are hiding facts, basically. In your affidavit, this is not there.
Yes, Lordship.
And so both of you are hiding facts.
We'll try to ascertain.
Now things are coming up.
Lordship. We'll definitely.
Okay, thank you.
Much obliged.
For hearing, item numbers 1, 2, and 3.
One of the reported earlier with the appeal, with page 48 of the petition.
Huh?
My with petition page 48. I mean, this was the appeal from who decide state as well as.
Page 48 of the writ petition. Which writ petition? Okay, just a minute. Okay, I've got the affidavit.
69 KR.
Yes.
Leaked. What happened here is that one of the was lordship. Here, paragraph 13, page 52.
Yes.
52. Paragraph 13. On perusal of the impugned judgment in order passed by the London Single Judge in all three petitions makes number. We find that the state government have been directed to declare the service of petitions worker employee into special payment to the writ petitioner as per OM dated 11/9 of 1998 issued by the government of India. Then OM dated 6/6/1995 issued by the state government. The OM dated 11/9/1998 issued by the government of India in the OM dated 6/6/95 issued by the government of Nagaland. relate to making express payment to the relatives of the government servant who died or contracted injuries or disease during employment as a government servant. So what was the ground is that the state was saying that these.
Come to para 15.
Yes. With regard to the direction passed by the learned single child regularization and such, for the purpose of mentioning pensionary penalty, we are of the view that the said direction did not take into consideration the eligibility criteria required in scheme of regularization made by such and such, going dated 2004. It produced. Well, what happened is that in the earlier proceeding, the big appellate court was mislead that stating that the OEM mentioned by the ministry
No, you
is
see,
not applicable in state allowance. That was
that with regard to ex gratia payment, that we cannot go into. That is the closed chapter. Ex gratia payment, that is a closed chapter.
Malord.
That is a division bench judgment.
Malord, OEM dated 11 September 1998. It speaks about the extraordinary.
Mr. Counsel, please
Yes.
come to para 15. Just come to the last two lines of para 14. Last two lines of para 14.
Accordingly, the OM dated 11/9/1998 issued by the government of India, OM dated issued by the government not applicable to the deceased person as you were not government servant at the time of their death.
Please read the next sentence.
Accordingly, there is no question of making extra payment on the basis of.
So this issue is closed chapter because this is a division bench. I am a single bench. Okay. So this issue cannot be gone into.
Malo, that is what I'm trying to bring it to your notice. Because I've located this one published by the government now in the compendium issued by the.
You go to Supreme Court against this order if you are doing this order has certain finality.
What I'm trying to see is that your lordship was misled that this is not applicable in Nagaland.
Maybe then but this order is passed in the division bench.
No, that is what I'm trying to see. It will be rather if I approach your lordship in the division bench, bringing that no, this OM is applicable in Nagaland, which I came to know only at the time of filing up my affidavit in reply. So that your lordship, the same bench have to consider whether it is applicable or not.
But that is only with regard to ex gratia.
No.
Now,
my lord, it includes extraordinary pension. 1998 OM.
Mr. Counsel, first of all, until you are regularized, there is no case.
My lord.
Until you can prove that you are you have got the right to be regularized, you have got no case. The thing is that you have asked for regularization, correct? Your prayer is for regularization.
My lord.
Your prayer is for regularization and ex gratia. Ex gratia has not been allowed by this court by the division bench judgment, and the question of regularization was to be considered by the government, correct? Now the government has considered it. Now the only thing we have got to see is
we have considered it denied. That is why
considered it in.
We have considered, but we have denied.
They have denied.
Yes.
So we have to see
That is
whether.
why I am before you.
Correct. So we have to see whether the denial is justified or not.
My lord.
So where is the denial? Where is that order denying you the regularization?
Annexure 8,
Annexure 8
page
is
57 of the repetition. Madam, in the light of the judgment order, the writ appeal number such and such, as considered your case and is concluded as under. Dated 22/9/2004 is under the regularization that is the scheme of work charged employee will be done against available vacancy of 50% of all regular vacancies of similar nature arising in a year. Therefore, regularization of work charged employees in the remaining 50 will be filled up as per the normal rules of recruitment rules. Work charged employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which he possesses the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior-most work charged employee in the relevant category will be regularized subject to his fitness for the vacant post. Dated 22/9/2004 is amended by 17/3/15 as under that all existing work charged in casual employees of various departments who are enjoying skill of pay in who have completed 30 years of or more continuous service as an 1/1/2015 by conversion of this post into regular ones, personal to term, is subject to the fulfillment of conditions as indicated. The department has examined your case and has arrived with the finding that your case is not covered under the purview of PNR notification dated 22/9/2004 and also 17/3/2015. Therefore, the department is declared to inform your prayer for regularization is hereby rejected.
yes.
The person who were to new to term also were regularized.
What?
Who were to new to term were also regularized.
Regularized when?
By different orders.
When?
My affidavit in reply.
Yes.
Let such and such appointed on 29 November 85 as work charge totally on fixed pay and promoted to post of work charge totally in the his skill as recommended by the departmental selection.
When was they appointed?
29 November 1985.
Regularized.
The others.
Others.
My lord. So I may be allowed to continue. Let me was appointed such and such. And some of the work charge to be appointed after the after 29/11/85. My lord. That is the person who were appointed later.
Where affidavit in reply?
Yes.
Page
4. 29/8/85 is the late thesis appointment. And paragraph 1, annexure 11. Number 70, Krishna Prasad, appointed in 86. 71, Narayan Pratan, 86. Same 86 87, 87, 87, 87, 87.
Where are you reading? Additional affidavit or affidavit in reply?
Affidavit in reply, my lord. And it,
Dated 12th March
yes,
2019.
additional affidavit in reply, my lord. Yes, I'm sorry.
Additional affidavit in reply.
My lord.
Dated 20, July 2022. Which page?
Additional affidavit in reply, my lord.
Which page?
Page 4.
Yes.
To let was 29, 11, 55. Then 5.1, annexure 11. If given year of agreement, that is 1986. Which is much later after the disease agreement. 1986, then annexure 12. These are 1988 appointees. Annexure 13, 1988 appointees.
Yes.
I'm for the AG. As far as my role is concerned, unless they finalize the pension, I have no role.
Yes.
Please, Lordship. My lord, here, our only stand is the petitioner is covered by OM dated 2004. And in that OM, it says that seniority committed. So as per the seniority, they are very much, they are not entitled.
No, please read his affidavit in reply.
Additional, my lord.
Additional affidavit in reply. Have you got it?
Yes, ma'am.
Come to page para 5.1. Please read what they're trying to understand. What they're trying to say. Yes.
And that Mondo appointed on 29 November as coaches to Bali on fixed pay and promoted to the post of coaches to Bali in the pay scale as recommended by selection board on 27/9/2000. Many of the coaches to Bali who were after his appointment on 27/9/2000 were led the few Mondo was appointed on 29 as coaches to Bali, and some of the coaches employees Jugali appointed on 29, 11,
After, not on.
yes, after 29, 11, 1955.
So you see the office order 2009.
Yes, my lord.
And he died in 2010.
Yes.
Then
So, my lord, here in this regard, the state is about to file reply, to counter reply to the this additional affidavit. But it is under preparation, my lord. I'm yet to file that reply, my lord. My lord,
where is your case? You after your husband never claimed regularization. Where is your right?
Yes, my lord. In fact, this case is covered by Supreme Court judgment passed in Mississippi case, my lord.
What does it say? Now, please read. What does it say? What is the relevant portion?
It's regard to posthumous.
Yes. What does it say?
Para 4.
Yes.
Having heard learned counsel for the state and counsel considering the submission made on behalf of the state, and having gone through the judgment and order passed by the learned single judge, confirmed by the division bench, we are of the firm opinion that the High Court has committed a grave error in directing the appellant to regress the service of the deceased employee 1 day prior to his death, Para 4.1. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein, original petition wife of the deceased employee, claimed the regularization after a period of 12 years from the death of the deceased employee. At the time of the death of the deceased employee, he was not entitled to regularization as he was much below in the list of the workers employee whose service were to be regularized. Under the regularization policy, the service of the workers employees.
But then he died when? He died in service, no?
Yes,
So this petitioner, he died in 2010.
yes, yes, ma'am.
And then his juniors were appointed in 2009, regularized in 2009.
So, may I continue, my lord?
I think you find that affidavit. Let him find the affidavit. Otherwise, what is there? There is something important. What? Is there something?
No, it is covered by, since it says that
So what does it say?
as per the seniority list.
As per the
It's much
seniority.
more, yes.
So his
At the
case-
time of his, at the time, during the lifetime of petitioner husband. She was,
So you, why aren't you understanding para 5? Come to para 5 of his additional affidavit, 5.1. You see Krishna Prasad, number 70. Have you got it?
Yes, madam.
Krishna Prasad. You see his date of appointment is 86. And this petitioner is 85.
Yes.
So petitioner's husband was senior to this Krishna Prasad. But Krishna Prasad was regularized in 2009.
And my lord, if the petitioners contention is that those juniors have superseded the
No,
petition.
it's not his case that he's not on that. He says that since he's juniors, he should be given the same treatment. He's not challenging that. Where's the question of challenging regularization? It's not a question of. Where's their case?
So I'm yet to find additional effect.
Okay, right. On the prayer of the parties. No, Mr. E. Shiva Home is granted 4 weeks time to file an additional affidavit.
Yes.
Additional affidavit. Additional affidavit. Huh? That's all. This is the matter after 4 weeks.
Much obliged.